the matter.
Okay, Friday.
Published.
Lordship, in item number 23 and 24, I am appearing for the petitioner, Lordship. Lordship, in item number 24, the respondents have filed a corrected affidavit in opposition recently, Lordship. Lordship, I am praying for a week's time to file a reply.
You are appearing for,
The petitioner, Lordship.
and they have filed a,
Corrected affidavit in opposition in item number 24, Lordship.
when,
On 6th, Lordship, 6th of May.
when?
I want a week's time to file a affidavit in reply, Lordship.
I don't allow this type of prayer at this hour.
Lordship,
This
otherwise,
scheme and
Lordship,
matter reaches
Lordship.
My lords, I beg to mention item number 25 of the daily list.
20.
5. My lords, I appear on behalf of the petitioner. I'm being led by counsel D. Das in the matter. Unfortunately, I've just been informed that his grandmother has passed away, because of which he cannot be present to advance the arguments in the matter, my lords. If I may pray for a short accommodation, my lords, in the matter.
At the request of the learned counsel appearing on behalf of the petitioner, matter stands adjourned to be listed on 15th of July, 2026.
Obliged, my lords.
My lord, in item 10, we have filed an affidavit, my lord. One of the evictions, same may be called for. my lord.
You have given the copy to the other side?
Yes. Copy.
And Mr. Bottakul, have you put the geographical coordinates
Coordinate, yes.
of all these four forests?
Yes, my lord, we have put the coordinate.
Wait, please, Lordships.
Mr. Rajchandran,
Lordship.
by the time last time I heard and now things have changed a lot.
Yes, Your
have,
Lordship.
you have a Allahabad High Court judgment against you. You have a Karnataka High Court judgment against you, and the
Yes,
Bombay
brief, Your
High Court judgment which you were relying has also been referred. And I completely concur with the views of Justice Kulkarni.
My lords, may I just submit? I'll submit. My lords, and as an officer of this court, I have only argued those matters.
Yes,
Therefore,
I've seen your names.
I must place it before your lordships. My lords, the Bombay High Court, in a batch of matters, has said that these are questions of larger importance, and therefore the matter has been referred to the Honorable Chief Justice to constitute a larger bench.
That I know, but
Lordships.
you, Mr.
The-
Rajchandran, if you have gone through the judgment of the Bombay High Court,
Lordships.
there it says that they duly accept the Allahabad High Court judgment.
My lords, they principally agreed with the Allahabad division bench, my lords.
That's not a question of larger issue, but the fact that there was a Nagpur bench judgment which was there, that judgment, the division bench of Bombay High Court said that, okay, we are not going to adhere to that.
No, there's certainly,
And
the
therefore,
lords.
the matter has been referred to.
This certainly, my lord, there is difference of opinion. My lords, today, as on today, there is a Bombay High Court at Goa, Bombay High Court at Nagpur, Bombay High Court at Aurangabad in favor of the SSC. The principal seat, Honorable Lord Justice Kulkarni, felt that no, I do not agree, because there are certain points which have not been answered. My lord, it's not that it is against us. Certain points which have not been answered by those division benches, and therefore the matter should go to the full bench, and the larger bench should decide that issue. That is one, my lords. Second, I must apprise your lordships, my lords. The similar matters came up before the Gujarat High Court. Gujarat High Court has not taken any view either way, as your lordships, my lords, has not taken any view either way, my lords. There, my lords, I must point out, I do not know whether my learned friend is aware or no. The learned ASG, Mr. N. Venkatraman, appeared, my lords, in that matter and made a statement before the Gujarat High Court saying that there are conflicting opinions of different high courts, right from Madras to Kerala, to Andhra Pradesh, to Delhi, to Allahabad, to Bombay. There are conflicting opinions. And therefore, he placed a submission before the division bench that please do not decide this issue either way, because there is a GST council meeting which is scheduled in June. And there is a proposal, I do not know, that they can make a submission. This is what he said, because I was appearing in those cases also. I must tell your lordships, my lord. He made a statement before the division bench saying that in the GST council, there is a proposal to bring about some amendment which will set to rest all these issues. And therefore, he requested the Gujarat High Court to defer those matters to July, saying that after that, we will apprise the court as to what has happened in that GST council meeting. That is one part. The third part, I must also apprise your lordships, my lord. In the meantime, my lords, what happened against the single judge of the Honorable Karnataka High Court, my lords, the revenue filed an appeal before the division bench of the Karnataka High Court. The Karnataka High Court has now delivered the judgment relying on the reference to the larger bench by the Bombay High Court, my lords, and
They
this
have also gone also on the Allahabad High Court judgment.
lordships.
I've read the judgment of Karnataka also.
The Karnataka division bench has now overruled the single judge, saying that no, this is permissible, my lords. In the meantime, that has happened, my lords. My lords, subsequently, what has happened, my lords, against the Bombay High Court judgments which were there in favor of the assessee, the Andhra Pradesh High Court which was there in favor of the assessee, the revenue has filed SLPs in the Supreme Court. The Supreme Court has, my lords, I'll share those orders also, has issued notice in all those matters, my lords. There is no stay of those judgments, my lords. And this fact was also brought to the notice of their lordship, saying that conflicting views are there of various high courts. And their lordship said, yes, we will decide these matters. And they have posted post vacation in July, my lords. I must just apprise your lordships of the developments, my lords.
Another aspect is pertaining to this is not only this matter pertaining to the 56 notification also, which I struck down.
Lordships.
Matter went to the Supreme Court out there, and there has been various views which have been expressed that has been stated. And therefore, it was stated that let the Supreme Court decide and the High Court should not decide.
Should not decide. Yes.
But the Supreme Court said that that doesn't stop the High Court from deciding.
No, certainly not. I never made that submission, my lord.
No, I'm not saying that.
Lordships.
You are saying it, but this is also the opinion of the Supreme Court.
Certainly, your
Because of
lordship.
the fact that the matter is pending or notice has been issued. Because if the leave would have been granted in those matters, the question would have been different.
Different position. Certainly.
It's still in the stage of SLP.
Certainly. Still at the stage of SLP, my lords. Therefore, my lords, as a duty, as an officer of this court, my duty is to inform your lordships as what has transpired since the last hearing, my lords. A lot of developments have happened. So therefore, my lords, one view could be, my lords, that your lordships can independently decide the issue and close it as far as your lordships are concerned. Either way, my lords, I am not saying either way. Or your lordships, my lords, can defer these matters to July post the, my lords. Something might happen, my lords, in the GST Council as a statement made by the learned ASG, my lords. Or even if the apex court decides this issue this way or that, my lord, then it will put to rest all these controversies. Otherwise, I'm ready, my lord, either
because there will be a requirement of that, even if the GST recommends.
Lordships.
If you go by the Mohit Minerals judgment,
Lordship.
it's just recommended.
No, it's only recommended. No. They'll have to bring about
there has to be an amendment.
Amendment, certainly, your lordships are right.
Act has to be amended.
Certainly. They can only recommend.
For example, in the GST recommendations which have been made pertaining to the input tax, credit tax and all this thing. There, the ITC, they have amended it by bringing in 16.4A and 16.5. No, these are things which required to be done by the legislature.
Certainly, my lord.
But as the legislature stands as it is, I am in favor of holding that I'm in favor of accepting the view of the Karnataka High Court.
No, I have to place
In
it.
fact, from the earlier times, before even the Karnataka High Court, my only anxiety is there's a difference between a system of adjudication being carried out under the GST as well as the income tax. Income tax has to be on the basis of the assessment years, and taking into account the slabs and everything are changed every year. There's a change, everything keeps on changing. There are various benefits every time a finance act comes in. But as regards to GST, the thing would be different. It is more like it's a combination of sales tax as well as the central excise region. So therefore, one part appears to be something with doing with the VAT and all, and the other part is the central excise or the finance tax regime, how it is being done.
So therefore, the interplay between yes,
are mixed up.
Certainly, your lordship are right.
So therefore, yes, I still remember the judgment, although that has been overruled later on, whereby Rainbow judgment was looked into. Rainbow has been overruled, and Union of the BSNL versus Union of India, wherein the Sumapal said that every assessment year has to be separate.
Separate assessment. Yes,
So that is a different concept for the income tax. But
Lordships.
that apply out there definitely.
Lordship.
Anyways, we have no problem in adjourning the matter if it is the case that you were saying that the GST is looking into, the GST Council is
Because
looking.
this is a statement made by the learned ASG before the Gujarat High Court. that-
Learned AG or AG?
ASG, Manoj, Mr. N. Venkatraman from the Supreme Court, the ASG,
Is additional solicitor.
That-
Additional Solicitor General, Manoj.
The Attorney General.
Assistant.
Additional Solicitor
Additional
General.
solicitor general.
Additional solicitor.
Lordships. Manoj, I am in my Lord's hands, Manoj. As a duty, I had to inform what has happened in various courts, Manoj. Supreme Court has
Yeah,
issued
that I've
notice.
seen in book.
Lordships. Supreme
But,
Court is examining the issue.
Mr. Ranchandran, you have to also see that now it is shifting.
Yes.
It is shifting.
Manoj, if that be so, Manoj, may I just submit? May I just
shifting.
please?
The judicial
If it
trend-
is so, Manoj,
the
if it is
judicial
so,
trend earlier
there was no need for them to step in to go to the council, so seek a recommendation for some amendment. That means, Manoj, that means two views are clearly possible. That, Manoj, my submission is that. My only submission is today that yes, there are divergent views. Lordships, about 10 judges taking a view, 10 other judges taking a view. Certainly, I'm not saying Manoj, Lordships will agree with me or my learned friend Manoj. Certainly, it's a point where two views could be possible. Certainly. Therefore, Manoj, the state has to step in, the union has to step in and bring about some amendment to clarify this issue forever, Manoj. It should not happen, Manoj, that I'm an assessee in Kerala or I'm an assessee in Andhra. And whereas my left hand, because today as an assessee, I have to obtain registrations in every state. Same person, same assessee, same person. I am treated differently in Kerala. It cannot be that I am treated differently in Delhi or that is why, Manoj, in that your lordships are aware. Last time I showed to your lordships, Manoj, in that Aparna creation, your lordships are aware. In Aparna creation, that party went to Supreme Court directly under Article 32, saying that I am in Delhi, I am bound by Delhi High Court. There are conflicting views, but I'll be governed by Delhi. There, the Supreme Court sent the matter back to the Delhi High Court, asking the Delhi High Court to re-examine the issue in light of Madras and Andhra Pradesh High Court judgments. And that matter is pending in Delhi High Court even today.
Did the Supreme Court say that? No.
Yeah, Manoj, kindly see.
Can you see that order?
Liberty was granted
Liberty was granted for the petitioner to go there.
to go there and show
But the Supreme Court never said that.
they were alive. They were, Lordship, may kindly see. Kindly see that. Manoj, with great respect, I cannot say that Supreme Court was oblivious of the different conflicting views.
No, the Supreme Court, because it was stated out there before the Supreme
Lordship, may
Court
kindly see that.
that Kerala had a different
The
view.
petitioner will be at liberty.
Yes.
The petitioner will be at liberty to bring to the notice of the High Court the decision of the Madras High Court and the Andhra Pradesh High Court, and it can consider and dispose of by the High Court on its own merits. Manoj, therefore, Manoj, my submission is that the Supreme Court was alive to the fact that there are conflicting opinions of High Courts, and therefore gave opportunity to this particular assessee where his High Court, jurisdictional High Court, had taken a view, saying that you please go back, show the different opinions and let them decide, let them consider, and then you can come back to me.
This is the matter pertaining to
Aparna, Manoj. Your Lordship, this compilation I had given to your Lordship in the last occasion.
the second compilation.
Second compilation, volume 2. Lordship, it says volume 2. Your Lordships have that? First page itself, Manoj. Kindly have the first page itself. Your Lordships have the first page. That is Aparna collection before the Delhi High Court. Civil writ petition 17077 of 25. Your Lordships have that?
Yes.
Your Lordships have this volume 2. The first page, the very first page, my Lords, the very first page.
Is the Delhi High Court judge.
Delhi High Court reproduces Supreme Court. Kindly read the Delhi High Court, my Lords. The present petition has been filed inter alia challenging the impugned order in original dated so-and-so, whereby a demand of so-and-so is being confirmed against the petitioner for financial year 17-18 to 21,
But
22.
Mr. Raichandran, don't you
Lordship.
think that the Supreme Court will say that why should we interfere under 32?
Yes,
Let
yes, certainly.
you have an opportunity under 22 to 6, you go before the Delhi High Court
Yes,
and
Manoj.
point out all these things.
And they are examining it. Therefore, Delhi High Court is also relooking into it, Manoj.
But
My-
then also Ambika Traders still holds the field for Delhi High Court.
That let them decide, Manoj.
Well, that's there.
That
But
let
Ambika-
them decide, Manoj. Let Delhi High Court say that, Manoj.
We have the Gujarat High Court judgment order.
No, Manoj. Gujarat High Court judgment order I don't have, Manoj.
Did the Gujarat High Court take into consideration then that aspect and then refer delay it?
No, Manoj. This was a statement made.
Well,
And therefore, Gujarat High Court has
but
deferred.
did the Gujarat High Court take into consideration that aspect and deferred the hearing?
Manoj, the Gujarat High Court, based on the statement of the ASG, simply deferred the hearings to July. They deferred all these matters. There was a batch of matters like this. They've deferred all these matters to July. Manoj, I can give the update to your lordship, Manoj. Their order doesn't say so, Manoj. I can show it to your lordship, Manoj. And I say this because I was a part of that batch, Manoj. May I just share this, Manoj?
Mr. Raichandran, you were all over the country in this series. Mr. Kyle, have you provided the written argument to Mr. Raichandran? Does anybody have the Allahabad High Court judgment?
Lordship, I had given it to your lordships, Manoj.
This is where it held that it is permissible. This is where it has been held it is permissible.
Permissible, Manoj.
Where-
The Allahabad High Court, I'll show to your lordships, Manoj. The Allahabad High Court said, I will not take the view the Bombay High Court has taken. I will also not follow the view the Delhi High Court has taken. A third view was taken, Manoj, saying that the scheme of the act,
Which one? You
the Allahabad High Court judgment, Manoj.
Page 2.
Lordship, may just give me
You're
one.
referring to SD Fresher.
SD Fresher, Manoj, but in the compilation, your lordships will be having the interim order. That's not the final order, Manoj.
Which is the final order?
Final order, Manoj, I'll just get it to you now.
Final order, I have it. It has been reported in SCC online, but in fact, you will require a magnifying glass to read it. Have you seen it?
Yes, lordships.
Yeah.
are right.
Isn't it? In fact, I'll try to read it from the Bombay High Court, where they have extensively quoted this judgment of the Allahabad High Court. There also it is also the Bombay High Court had maintained the font. This is Kulkarni. Otherwise, the judgment has a bigger font.
Bigger font,
But
Manoj.
when he is reporting
That
the
is-
Allahabad High Court judgment, and it has been extensively done, but he maintains the font.
Font. Original font. I can place it for your lordship, my lords. Because what the Allahabad High Court explains is that though I agree that the entire scheme of the act talks about one return, one assessment. Okay. However, once we come to 73 and 74, 73 and 74 are provisions for adjudication. Adjudication is separate from assessment.
So the Allahabad High Court refers to three systems. One is assessment, one is adjudication, one is recovery.
Recovery, lordship.
So it extensively deals with this procedure.
Deals with this process, my lord, saying that there is a difference between assessment, that you may be right, that the court says you may be right as far as annual assessments, filing of returns, etc. Annually, everything is annual. Assessments, returns, registration, books, records, all the sections that you're referring to is perfect. That goes as far as assessment is concerned. But once we come to 73 and 74, those are provisions for issuance of notice and adjudication. So adjudication, and last is 79, which is for recovery. So the Allahabad High Court, with respect, explains that the process for adjudication, don't mix it with assessment. It's separate, it's independent. Assessment has to be done annually, you may be right. But adjudication, there is no such requirement, and therefore it can be done for a more than one financial year. That is what the Allahabad High Court says.
And another thing which is notable to take note of in all these three judgments, including the Delhi High Court judgment, says that unless there is an amendment by way of a legislation, it would be, if we held that each has to be separate, it would be a judicial legislation. This appears to be the common trend in all.
All laws. And laws likewise, which is in favor, also says the same thing, that we cannot read words to say, unless the legislature says, we read it as plain and simple, tax period means financial year. That's the only bottom line, with great respect, crux of the issues, that only. Other the tax period is one or more than one. The Kerala High Court division, again, single judge took a view against. Kerala High Court division bench overruled it. Andhra Pradesh High Court division bench, Bombay High Court at Goa, Bombay High Court at Nagpur, Bombay High Court at Aurangabad, all said this. The Madras High Court took this view, Manoj. Karnataka single judge took this view, but division bench has overruled it, Manoj, now. And the Allahabad High Court has taken a third view, Manoj. Specifically, they say, we don't want to go down the Delhi line. We don't want to go down the Bombay line. We will examine the scheme. That, Manoj, may kindly look at the act itself, Manoj. With great respect, Manoj, with greatest of respect, your lordships may agree with me or disagree with me. Your lordships may concur with the Delhi High Court view, Manoj, or the Madras High Court view, or the Karnataka High Court view, Manoj. Manoj, the Allahabad High Court view, Manoj, with great respect, Manoj, in my respectful submission, does not make this distinction correctly. The act itself says, kindly have a look at the definition of assessment. Assessment includes adjudication. It includes re-adjudication, it includes reassessment, everything. Therefore, that distinction, which is sought to be made by the Honorable Allahabad High Court, Manoj, between assessment and adjudication, doesn't exist. In GST, it doesn't exist. What, Manoj, with great respect, they were weighed with is the excise regime, is the service tax regime, where this concept of assessment was not there at all. There was no assessment. Lordship, may kindly have the act. Kindly have the act for a minute, Manoj.
Yeah.
Lordship, may kindly have 211. Section 2, subsection 11, my lords.
Yes.
Assessment means determination of tax liability under this act and includes self-assessment, reassessment, provisional assessment, summary assessment, best judgment assessment, and includes, Manoj. Kindly have the main section, means determination of tax liability under this act. Kindly have 73-74. That is determination of tax liability only. That is determination of
But tell me one thing.
lordships.
Does the CGST Act conceive of reassessment? No.
Lordships,
Does the CGST Act conceive of reassessment? No.
lordship, that's my submission. 73-74 is a provision for reassessment. Because when I file my return, lordship, it's like income tax. When I file my return, I self-assess. I do my own assessment. My tax liability is this much. When they issue a notice on that return, it is a notice for reassessment under 73-74. 73-74 is the only provision in the entire act for reassessment. Otherwise, those words become redundant. And it cannot be lightly assumed that those words are there. Self-assessment, reassessment. Reassessment is by them under 73-74. That is one. Second, Act says assessment means determination of tax liability. Kindly
Well,
have...
otherwise, you don't have
Sorry.
a separate, like in
No, my
Income
lord.
Tax Act, you have a separate provision like 148
Lordships,
pertaining to reassessment.
lordships.
Here, the what is the actual concept of reassessment? The reassessment, if I understand correctly, if there is an escape from the turnover,
Lordships,
thereby prejudicing the revenue,
lordships.
these are the two prerequisites.
Requisites, lordships.
Then a notice has to be issued asking them as to why there should not be a reassessment done. This is now as per the scheme from 2021, 148A.
Lordships, lordships, lordships.
Notice will be issued under 1, 2, and D, A, B, C, and D.
Certain
There will be an
lordships.
order passed.
Yes, your lordship.
And once that order is passed, then you are to file your fresh return.
Fresh return.
That is a reassessment concept.
Lordships.
But here, do you have the scope of filing a fresh return after the reassessment under 73-74?
No, my lords.
So therefore,
Hmm.
wouldn't that be an adjudication different from reassessment?
Lordship, there are two answers, my lords. There are two answers.
Because reassessment means a thing where you are assessing the particular thing. Yes, you may have it. But then also, what you say that this is the escape turnover. So now you file your fresh return. Therefore, if we remember the earlier trend prior to the 2021, there used to be a lot of cases under 148 questioning the reasons to believe.
Lordships.
There was one judgment, I forgot the name, I think DCM or something, wherein it says that the Supreme Court, it was a very short judgment out there. That first
GKN, GKN, drive shaft.
DKN, yeah.
GKN drive.
When it says that first you
lordships
have
are
to
right.
file your returns and then you come and challenge whatever venue, and if you have anything, file an appeal there against it.
Lordships.
But then also there has been a lot of questions on as to whether the reasons to believe was there for which is a condition precedent. And I think that led to the amendment of 148A.
2021 amendment. Lordships.
But at the end of the day, you then also, after the reassessment is being done, that order is being passed, thereby opening up the assessment. Once the opening it it is more like a review. And
Your lordships are
in a
right.
more sense, we review this order and then open up the writ petition for a final adjudication. Whereas in this case, you open up the reassessment, which is otherwise concluded as per law. If you will do your self-assessment
Lordships.
or even your scrutiny assessment or your audit assessment, all these things which has been done, you open it up and then it is open again to file. But then also you have something to be done by the particular person concerned, the SSC, for filing of a return.
Lordships.
And if you don't file your return, then it will be made a best judgment
Judgment
assessment.
Lordships.
This is the very concept. But
Lordships.
here, under 73, it adjudicates the amount, how much you are payable,
Lordships.
what is the interest, what is the penalty, if it is a case under 74A.
Lordship. My submission is that. Lord, there is no, your lordships are right. There is no special mechanism like income tax for reassessment. If at all, that word has to be given a meaning. Reassessment. Where is reassessment? There are only two sections in the entire Act, 73 and 74, which provide for opening of my self-assessed declaration. Because assessment, your lordship may kindly see, also includes self-assessment. It includes I will self-assess. I will file my return.
But
Assuming, my lord,
again, at the same time, does the CGST Act perceive of a best judge's judgment assessment?
yes,
Which is the
yes, Lordship, may kindly see. Kindly have section 60. Kindly have chapter 12, assessment. Kindly start from 59 onwards. Kindly start from 59.
Yes, assessment.
Lordships have assessment,
Yes.
chapter 12.
Yes.
Section 59 provides for self-assessment.
Yes.
Every registered person shall self-assess the taxes payable under this act and furnish a return for each tax period as specified under 39. This is my assessment, Lordships.
Okay.
Then 60 provides for provisional assessment. Subject to the provisions of subsection 2, where the taxable person is unable to determine the value of the goods or services or both and determine the rate of tax applicable thereto, he may request the proper officer in writing giving reasons for payment of tax on a provisional basis, and the proper officer shall pass an order within a period not later than 90 days from the date of receipt of such request, allowing payment of tax on a provisional basis at such rate or at such value as may be specified by him. The payment of tax on provisional basis may be allowed if the taxable person executes a bond in such form as may be prescribed and with a surety or a security as the proper officer may deem fit, binding the taxable person for payment of difference between the amount of tax as may be finally assessed and the amount of tax provisionally assessed.
I think 62 may come within the ambit of a best judgment.
62, my lords.
This is scrutiny assessment.
This is scrutiny
61
assessment. 61 is again, they will scrutinize my return. Scrutiny assessment. They will scrutinize
I
my
think 62 will
62
be the
is
best.
non-filers. Assuming I don't file my return.
But then also 62, although it says about it's more worded like a best judgment
Lordship,
assessment.
best judgment.
But then the legislature makes it very clear that this is notwithstanding the powers which are reserved under 73 and 73 and 74.
Certainly. That is, my lords, because that is reassessment. That's my submission. That is reassessment. That is why the section 211 clearly talks about assessment means determination of tax liability, full stop. Kindly do not go into self-assessment, provisional assessment, reassessment, adjudication, etc. It stops at determination of tax liability. Are you determining my tax liability or no? If the answer is yes, it is assessment. It is assessment.
Then at 66 is the audit assessment.
66 is not special audit.
This is the audit assessment.
Yes. 65 is audit by the authorities. 66 is by the special chartered accountant appointed by them.
But then also again it reserves the power of the 73.
In the 73. Because 65, 66 say that if suppose during the course of audit we find some short payment, etc., the proceedings will be initiated as per 73, 74. 73, 74.
Where the special audit auditor results
Kindly
in
have that,
detection
Manoj.
of any tax not paid or short
Short
paid,
paid.
or erroneously refunded or inputted wrongly availed or the other proper may initiate action under 73 and 74. So therefore, even in a case when this or special audit is being carried out, then you can go for this 73 and 74. So it is similar to like when audit sometimes happens, which leads to in the income tax,
Lordship.
you initiate then proceedings under 148.
Lordships.
140.
Lordships. I'm obliged. It's exactly like. It's exactly. And kindly
But
now see
at the
73.
At end of the day,
Lordships.
in all these assessments, whatever may be, it is the taxpayer has to, the SSC has to file again a fresh return.
Under income tax, my lords.
No, here,
my lords, you have to file a return.
self-assessment, you file your return.
Self-assessment, you file your
Then
return.
once it is being done under the provisional assessment, you kindly see this. Provisional assessment also you have to file.
Yes, my lords.
Yeah,
Provisional
you have to
assessment,
file your
also
return.
your return.
And even in 62 also, where
You have
it
to
is
file
the
your returns.
best judgment assessment.
Yes, my lords.
Kindly see 62 too.
Till
Where
62.
furnishes a valid return within 60 days of the service of the
assessment shall be
assessment
deemed to
order
be
and
withdrawn.
shall be deemed to have been withdrawn, but liability of payment of interest under so and so for the year shall be continued.
Yes.
So therefore, that will be withdrawn. That means you have to again file your
I have to
return.
file my return.
But 73, 74 does not conceive of filing a return,
Filing on a return, my lords.
which is the difference, which is the only difference in respect to a reassessment.
Yes, my lords, certainly.
So
that-
it is a mixture of a reassessment with an adjudication.
My lords, every assessment will include adjudication. What is assessment, my lords? I apply my mind, I adjudicate whether you are liable, not liable, whether there is short payment or not payment. Every assessment, my lords, what is assessment even otherwise? Forget this for a minute. Even otherwise, I have to assess. Your lordships do that, my lords. Your lordships assess whether this submission has to be accepted or not. That is what 73 and 74 is. Giving this word of adjudication. My lords, where is that word adjudication? Kindly see, kindly have 73. Where is this word adjudication coming? 73, 74 only talks about determination of tax liability. Kindly read the 73, 74 first line itself, my lords. Determination of tax not
And it
paid.
comes under the chapter demand and recovery.
Demands and recovery, my lords. Because 73, 74 is Lords, may kindly see the first line itself, determination of tax. Now kindly see 211. Read this with 211. Assessment means determination of tax liability. Meaning, that is the only meaning. This is nothing but as a part of assessment only. It is not independent of assessment. It is not divorced of assessment. It is part of assessment only. Therefore, with greatest respect, that line of reasoning, my lords, is not correct in my humble submission for my lord's kind consideration. A lordship may independently come to a conclusion, reading 73 and 74 on a standalone basis. That's a different matter. I will not, my lords, I will make that different submission for that. But this line of reasoning, that 73 and 74 are adjudication and assessment is different. No, it's all part of assessment. The entire act construes only one. Everything is assessment, whether it is self-assessment, reassessment, provisional assessment, or best judgment assessment, or determination of tax liability.
Because in the Value-Added Tax Act,
Lordships
the assessment orders are appealed.
are appealed against.
So assessment becomes a part of the adjudication.
Adjudication itself, my lords. Yes, my lords. Assessment is part of, my lords. Assessment includes adjudication. Because against this assessment order, even under the old VAT regimes, your lordships are aware.
And similar is the Income Tax Act.
Similarly, assessment orders are appealable.
And what about the Finance Act?
Finance Act also, my lords. Orders are appealable. These orders, my lords, 73, 74 orders are also assessment orders, which are appealable to the appellate authority. And from there to the tribunal, then to your lordships, my lords. Entire scheme, same scheme of the act, my lords. Therefore, my lords, the distinction sought to be made, in my respectful submission, is not correct. Your lordship may hold, even otherwise your lordships may hold that my submission is not correct, is a different matter. But not on this line of reasoning, my lords. On this line of reasoning, my lords. Certainly no. That will be incorrect, my lords. That will be incorrect, my lords.
One has to go thoroughly into this because of the main problem is reading the judgment is very difficult.
Yes, my lord. No, my lords. What I will do is, my lords, I'll give your lordships the web copy, the downloaded copy, because the reported judgment is like that. Your lordships are right. It's too tiny a font for anybody to read it, my lord. I'll give your lordships the web copy. It's a 100-page judgment. I will circulate it to your lordships, my lords. But my lords, I have read the judgment, my lord. This, in my respectful submission, as a part of my submission for my lord's kind consideration. This is the line of reasoning of the Allahabad High Court, my lords. That is why they say we don't look at Bombay, we don't look at Delhi also. This is the reasoning that we give. And with great respect, my lords, the reasoning of their lordships, my lords, proceeds on being clouded with central excise and service tax. They say so. Central excise, always it was done for 5 years. You never had objection. Because central excise scheme was different. There was no time limit for adjudication. There was no time limit for passing assessment orders. There was no time limit for issuance of the notice also before adjudication order. Scheme is completely different, my lords. Therefore, my lords, I never placed before your lordships the scheme of income tax. I never placed your lordship before the scheme of sales tax also, or central excise.
Because normally in income tax, you have a period within which you have to complete the assessment.
Lordship, you have to complete the assessment. My lords, because why, my lords, income tax always was like that. Sales tax was always like that. They had a period of 8 years for assessment. Income tax is 4 year, they had 8 years of assessment. Therefore, GST law is modeled exactly on that. With great respect, my lords, GST is completely different from the regime of central excise and service tax or customs that the union officers have ever seen, my lords. States were always used to this annual assessments, annual appeals, annual return, annual assessment, annual appeals. That assessment is a part, the adjudication, my lords, so-called adjudication is a part of assessment only.
So if that be so,
Lordship.
then wouldn't it be a case of prejudice being caused? Then only you can challenge that order. See, the legislature could not, in 73 or 74, do not say that every year there will be a different adjudication of what determination of tax separately by issuance of a sovereign. It doesn't say so. Now, if there is a case of prejudice being caused to you, then it would be a case for which an interference will be there. But would it be a case of the authority having no jurisdiction?
May I address your lordship's query, my lords? My lords, my submission is the proceedings are without jurisdiction because they could not have done this. That is what we are before your lordships. Your lordships have to rule either way on that. For them being within jurisdiction or without jurisdiction, my lords, I did not show prejudice to your lordships. Maruti Suzuki Supreme Court, my lords, I'll place before your lordships. If a particular act of the authority is without jurisdiction,
No. Therefore, my question is bit beyond that. My question is, the legislature do not mention that for each financial year or each step.
lordship, that's what your lordships have to interpret. 74 says that.
You are
73
referring to 72 on the 74 or 73 on the basis of 7310 or 73.
Lordship.
10,
Yes, your lordships.
where they have used the period of limitation now.
Lordship.
That's okay. But the fact remains that at the time of issuance of the show cause notice, which is 73-1 or 74-1, there's no mention as regards the period.
Lordships.
It doesn't say for any, it neither says for any tax period, or the word, if it is, or it doesn't say that for a particular tax period.
Lordship.
It doesn't say so. Therefore, in all the other judgments, whatever views have been taken, they have consistently held, those 3-4 judgments have consistently held that if we use the word any tax period in the subclause 1 of section 73 and 74, will be legislative,
Lordships.
which the legislature ought to have done.
Lordships.
Now the question arises, is you are prejudiced. If you are prejudiced, can you touch on the basis of the prejudice or question of jurisdiction? My question is,
I quite see what falls from my lord. My lords, here is a case where we are against the assessment. Lordships. Your lordships may be right, my lords. If your lordships put this query to me when I challenge the notice itself, saying that at the notice stage, when it is under 73-1 or 74-1, at the notice stage, what is the jurisdictional error committed by them? You please show me. Lordship. Today, when they pass the assessment order, my lord, certainly there is a jurisdictional error because today 73-1 has to be read with 73-2, 73-2 has to be read with 73-10. That's what your lords have to interpret, my lords, whether this particular exercise of passing a consolidated order for 5 more than 1 financial year, 4, 5, whatever that may be, my lords, is without jurisdiction or not, my lords. For that, my lords, for 2 reasons, I'll submit. There is certain prejudice. I'll show, my lords. I'll show.
no, if it is a question of prejudice.
No, I need not show prejudice.
No. You need not show prejudice if there is no jurisdiction.
Lordships.
That I understand.
Yes, your lordship.
But if there is a jurisdiction, then you have to show prejudice. You can very well show
Lordship,
prejudice.
lordship, please.
And if you have to show prejudice, isn't it then take it outside the realm of this 226 court.
Lordships, I quite see what falls from my lord, my lords. My submission is this, my lord, limited. We are questioning the jurisdiction itself, that your lords have to decide whether they have jurisdiction or no in light of 731 read with 732 and 7310. If your lordships hold that they have jurisdiction, my lords, if they have jurisdiction, then I am out of court, my lord, then I have to pursue the other remedies as far as the other issues are concerned. If your lordships hold no, that the entire exercise of passing the order for a consolidated period is without jurisdiction, my lords, because then they have to pass fresh orders in light of what your lordships hold, my lords.
Then you do one thing,
Lordships.
you provide your whatever detailed argument you want to give him, and also the judgment which the Allahabad High Court in a better.
Allahabad High Court, I'll give it to your lordship. I'll give the web copy
Let me
only.
reserve the judgment and then look into it. Although I agree to you, what do you say about the Allahabad High Court judgment?
Lordship,
Yeah,
lordship.
I agree to this.
That, my lord,
Because
your
there
lordship may
is-
not.
it appears to be means something, it has a part of it.
Yes, my
It
lord.
means you cannot say per se 73 and 74 to be a pure adjudication of.
It is not divorced,
It
my
is-
lords.
It is inclusive of the assessment proceedings also,
Certainly, certainly, my lord, certainly.
because they determination of that.
Yes,
Yes, I
certainly, my
understand
lord,
that.
certainly.
But only problem where Mr. Raichand, normally when you appear before me also,
Lordship.
I'll make it, all lawyers will say, I make it very clear at the time when I reserve. My only thing to look into it is as to whether 73(1) issuance of a notice, consolidated notice is permissible under 73(1).
Lordships.
Once I hold that, if I hold it in your favor, then entire proceedings over. If I hold it against you, then I'll give you time during the pendency of the proceedings out here.
Certainly, my lord. We are in
The
time before
for
lordship.
filing an appeal, because you have the problem out there with the limitation and
No, my lord,
So I'll
these
give you
matters,
some
we are always
20, 30
limitation.
days time.
Yes,
for
my lord.
that. This is what I've.
Certainly, certainly, my lord. So I'll be quite bowed down.
That is the only thing I look at,
Lordship.
because these are the three, four views which are there.
Lordship.
Look into it, and when only
Lordship.
thing is the Allahabad High Court thing has.
I'll circulate it. I'll circulate it for lordship. I'll circulate it. Yes, this is the one.
Lordship, another thing,
I'll circulate.
appellate tribunal is functioning in Lordship by
Well,
notification.
that is why I say.
Time has been
No, I
extended.
looked into it.
Lordship.
Then after you said that day, I looked into it. Now there are around 150 or 170 matters pending in ITT.
No.
I looked into ZTA.
Because they are, that, my lord, my learned friend, the tribunal has been notified. Members have been appointed. They are not functional.
Yes, it's functioning.
No, they are functioning. There are pending.
Yes.
There are lists.
What has happened is, my lords, I'll tell, because the last week, my lords, before the division bench of the Tripura High Court, they made the same submission. Their lordships, Honorable Lord Justice Ramachandra Rao said, show me one cause list of any one day. They may not be actually sitting also, but there is a cause list. Then they came out and made a statement that Tripura is a circuit bench for principal bench at Gauhati.
Yes.
Gauhati is the principal seat. Here also they could not find any cause list for any matters being listed. So they are not functional per se. Because
No, they are not functional or may not be functional at Delhi, Calcutta, but they are functional at Delhi.
It is functioning, Lordship. I
In
met
Calcutta.
in Gauhati also.
Oh, you are Guwahati also
Yes,
you
Lordship.
have?
Yes, Lordship.
no,
Oh, they have recently appointed some.
no,
Yes.
members have been appointed, my lords. I am not saying so. Members have been appointed, but the court is not functional. There is no cause list. There is no sitting. Only what is happening is filing of the appeal online. I can do it from my house also. Online is extended up to 30th of June 2026. Thereafter, something will happen, my lords.
It's
That
okay.
is what.
No, but anyways, if these are circuit benches. These are circuit benches.
No, Guwahati is
Guwahati
a
is the
principal
permanent
bench.
bench.
It's a permanent bench.
Understood. But
Lordship.
then also it controls under the Delhi bench.
Yes, Lord.
Manoj, what the scheme is, Manoj, if I may place it for Lord. The principal bench at Delhi, Manoj, will decide only issues relating to place of supply. So for example, whether there is a sale from Gauhati to Calcutta, it's an IGST sale. So place of supply is Gauhati or place of supply is Calcutta. That issues will be decided by the principal bench at Delhi. Then every state has state benches. So all other issues, whether it is valuation, whether it is classification, whether it is input tax credit, whether it is short payment of tax or non-payment of tax, etc., etc.
So then you are enjoying some interim orders here.
Lordship, yes, my
Yeah.
lordship. Yes,
So
your
therefore,
lordship may
then
protect
in
me.
that regard, I have to give you 30 days. If I- in,
Yes,
the
your lordship, you have to
circumstance,
protect me.
I'll
from
give
that.
you 30 days for filing an appeal. Until the matter is not being taken up by the
Lordship.
court, the matter, the interim order which was
Will
passed on
continue.
shall.
Lordship.
I think if I pass that on.
If your lordship passing that order, certainly, my lord. That's my submission. Manoj, only one more point. Sorry,
Because I
my
think in that he's saying that the matter is the court is functioning.
No,
So
no,
that- no, it's okay. That is
Right.
his submission.
That is a submission.
So therefore, I take it on that.
Yes,
basis,
my lord. Your
and then I
lordship.
protect you till then.
Till the matter is heard, my lord.
Because then the court will be only deciding on the question of other aspects. There's some violation of some sections which you have mentioned in those matters.
Yes, my lord.
There's some violation of such as the one judgment of Justice Kulkarni were placed on Bombay High Court.
Lordships.
These are issues to be then decided out there in all those.
Lordship. Lordship, only one more submission.
Yes.
In these batch of petitions, there are two petitions by individuals, my lords, where individuals have been imposed penalties under 101, 122 1A. That I showed to your lordship, my lord. The Bombay High Court has taken a view that 122 1A cannot apply qua the individual. It has to apply qua the taxpayer, the company. And company has also been penalized under that section, my lords.
But there also isn't it the case of consolidated show cause notice? No.
No, my lords, that will not be consolidated because 122 1. My lords,
No, I'm asking you, is the issue of consolidated show cause pending there?
no, because what had happened is the consolidated issue is qua the taxpayer, qua the SSC. Two of those individuals from that company have been penalized under 122 1A. So those two petitions are also before your lordship, my lord. Those petitions only involve those issues of 122 1A. Consolidation is not those in the individual petitions. So either your lordship's two-fold, my lords. One, it is squarely covered by the Bombay High Court, affirmed by Supreme Court now, that individuals, my lords, because individuals cannot be penalized for 100 crores. You have not.
Which are the two matters?
Lordship, those two petitions are. One is Mr. Mayank Bansal. It's on your lordship's board.
And number 3.
And number 3, and Mr. Nadar Hussain. That is writ petition 25 of 26, my lords.
So these are nothing to do with consolidation.
No, my lords. These are no
So
consolidation.
we are to take out these two matters outside from this list.
Lordships.
Huh?
Lordships. Or your lordships can independently adjudicate, my lords.
So this has to be independent
Independently
because this has
adjudicated.
nothing to do with these.
This has got nothing to do with bunching, my lord. This I am only qua the
So
penalty.
cannot. So the issue of consolidated VI will be 1, 2, 5, and 6.
Lordships.
You may not be there in 5 and 6. 5, 1, 2, and 5.
Lordships.
Okay. Yes. Okay. So these will be the consolidated mark here. 1, 2, and 5. And 3 and 4 is out.
3 and 4 in right, because it was along with the company.
I heard Mr. Raychandran, the Learned Counsel, appearing on behalf of the writ petitioners in WPC number 2922/2025 and WPC number 20/2026. I've also heard Ms. So-and-so, who appears on behalf of the writ petitioner in WPC number 1113/2026. The issues in these 3 writ petitions are similar, and as such, Mr. S.C. Kyle, the Learned Senior Counsel, assisted by, who is also the Standing Counsel of the CGST Department, assisted by so-and-so, appears on behalf of the CGST. Mr. B. Chaudhary, the Learned Standing Counsel, Finance and Taxation Department, appears. Finance and Taxation Department, Government of Assam. The 3 petitions raises common issues. This court have duly heard the learned counsels and the judgment is judgment reserved. This is for 1, 2, and 4. As regard 3 and 4, we say, heard Mr. Raichandran, the learned counsel, appearing on behalf of the writ petitioner in both the writ petitions, and Mr. S.C. Kyle, the learned senior counsel, as well as the standing counsel of the. This is the, you are appearing for whom?
Lordship,
CGST is there
yes, Lordship.
for the CGST.
DCGI also part,
Huh?
DCGI. In item number, in Mayank Bansal.
Respond number 3 is with the DGGI, my lords.
You are for that, no?
Yes, Lord.
For the DGGI. And Mr. So-and-so, who appears on behalf of the Finance and Taxation Department of the Government of Assam. Hearing concluded, judgment reserved. So these are two orders, huh? These are two segregated. Because
Much of it.
well, Mr. Rajendra, you just provide me, or if you want to put a note, you can put a note.
I'll put
on
a
that.
note, my lords, in both these
And-
petitions
And I have
separately.
seen all I've got all your judgments out here, which you have placed. You
Yes,
have,
ma'am.
you have given me two compilations.
Yes, your lordships, volume 1 and
One
volume
is a
2.
compilation, but the volume 1 and volume 2, and then. And the other matter where you are saying about those 2, 3, and 4,
Yes, my lords.
this is the Amit Manilal Haria judgment
Yes, my lords. Yes.
and Santanu Kumar.
Shantanu. Yes, your lordships, Shantanu.
This
That
is
was
by the-
affirmed by the Supreme Court, my lords.
And then thereafter there is another judgment passed again. But this is the later judgment, na?
Late judgment is
Manilal
Amit is
because
late.
Santanu Sanjay Hundiari was taken over to the Supreme Court.
Supreme Court, lordship,
And the
lordship,
Supreme Court did not interfere.
lordships.
And then comes again, the matter came up before the division bench of the Bombay High Court in Amit Manilal Haria,
Lordships,
where
lordships,
he has dealt with this.
lordships, lordships.
In these two matters, I
Not
think
yet.
the Bombay High Court judgment is
Not
clear on that. So 18 hold 3 and 4, right? And these are. Anyways, Mr. Rachani, it was a very pleasure hearing.
It's my pleasure. We are obliged, my lords, deeply obliged for a kind and patient hearing, certainly, my lords.
Much of it.
It's a privilege. My lords, I'll just place this order, my lords, where they made a statement.
Which one? Oh, this one.
My learned friend made a statement.
No, therefore, my order would be this. If I pass an order
Lordships.
holding that the jurisdiction is there,
Certainly, my lords.
then I will give you 30 days for filing an appeal.
Lordships.
And till the appeal is not considered, the interim orders passed.
By lordship
shall
and
be
protect, my
considered.
lords. Lordships. No, my lords, why I'm saying this because they made a statement. It is stated by the counsel for the respondents that the GST appellate tribunal at Gauhati is not functioning. They made a statement. I am not saying this.
Oh, no, at that point of time, it may not have
No,
been.
7th of May.
Oh.
Today we are on 10th, 11th. 7th of May, it is stated by the counsel for the response the GST appellate tribunal is not functioning as of date and only e-filing is being done. And no case has been taken up by the said appellate tribunal in the last 3 months. Counsel for the respondent has also not been able to place on record a single cause list of any single day where the tribunal is being hearing. Writ petition is entertained and issue notice to the respondent. I only appeared, my lords. I will never make a statement like this.
No, no, no.
Lordship, my specific instruction is the tribunal is functioning in Gauhati.
It's okay.
Lordship,
You,
the same, my lords.
you will be protected.
Yes, yes, your
till
lordship.
it
Yes,
is
certainly,
nothing.
certainly. I'm not saying that, my lords.
Much of it.
What? Which one? You are referring to the Karnataka single bench. Not there. And what does this court hold? What does the judgment of this is the IPC claim is different. In the case of what is this judgment case number? PepsiCo India Holdings. What is this matter, Mr. Sai?
What's a PepsiCo?
The SMT 10 issue was there. The PepsiCo Lordship we filed writ appeal that is pending.
What is that matter?
Lordship regard in this case, Lordship, in this case, Lordship, the notice was directly sued without issuing SMT 10. Under section 61.
This is pertaining to the input tax credit. No?
Yes, sir.
It has nothing to do with this. Produce the business inside.
I think
So this is on the question of limitation.
which one?
Limitation. Itu yet why do you not? Itu hey, one. This is for item number 5, no? Yes, I got it, yeah?
Because PepsiCo, what your lordships held was that you cannot resort to 73 unless you go to 61 scrutiny.
Okay.
That is 73 is married to 61 scrutiny. 74 is independent because that allegations of fraud, suppression, etc. are there. That you may need not necessarily go through scrutiny. Lordships. In that context, Manoj, what my learned friend seems to rely upon to suggest is that
But if you see 61,
lordships.
61, it's okay. But how do you or proceed? Now, but what do you say about 61.3? In case of non-satisfactory explanation is furnished within 30 days of being informed by the proper officer or further period as may be permitted by him where the registered person after accepting the bill fails to take the corrective measures in his return for the period in which discrepancy occurred, proper officer may initiate appropriate action including those under 65, 66, 67 or proceed to determine tax or other dues under 73 or 74.
Lordships. Therefore, what your lordships held is that 61 procedure is mandatory. 61, you will do the scrutiny of the assessment of the returns. Then you will ask questions. I will give an explanation. If you are satisfied, then there is no problem. If you are not satisfied, then you will proceed to 73, 74, 65, 66. So it's like a step-by-step procedure. Don't straight away come to 74 notice. That's what your lordships held, my lords, in PepsiCo. And in that context, what my learned friend seems to rely on, it's not got nothing to do with bunching. What she seems to argue is, and in my respectful submission, or rightly so, she says that 61 also, the scrutiny also is for the return. Every return. It's not that they will scrutinize 4 returns together. Scrutiny will be that return for that financial year, which leads to 73 and 74. And therefore, 73 and 74 also talks about that return, that is that tax period. That tax period.
This is this is an analogy drawn from that judgment.
Yes, your
but
lordship.
not
Yes.
held in the judgment.
No, my lord. This is what my learned friend seems to suggest, that it flows from that judgment. Lordships. Correct? No?
Lordship.
Yes. Lordship. Grateful, Lord. We have extremely obliged.
You ask somebody to give it within 2-3 days or 5 days.
Yes, my lord. We'll circulate the written note also and the Allahabad High Court. Yes. And lordships want the Karnataka DB also, my lord. Because
I have the Karnataka is better. No problem with that. Karnataka and Bombay is not a problem,
Lordship.
but the maintaining of the font out there.
Lordships. I'll do that. Obliged.
Your Lordship, I am appearing on behalf of Mr. H. Gupta. I have already circulated the adjournment slip.
We adjourn the matter today.
My lord, they informed me, my lord, that he has some medical grounds, my lord. He has undergone.
What happened to Mr. Gupta?
Yesterday, he has undergone some surgery, my lord.
You are appearing for Rana Construction. You have filed your affidavit. Okay, in the next step you file. It has been informed to this court that Mr. H. Gupta, the learned CGC, who is appearing on behalf of the Union of India, had to undergo certain medical procedure yesterday, and as such seeks for some accommodation. Mr. Ardeka appears on behalf of the respondent number. RM Deka appears on behalf of the respondent number so and so. Seven, right? And submits that the respondent number 7 would like to file an affidavit. Because it is at your instance everything happened. You should file. Are you filing it or not? How much time do you require?
2 weeks.
List this matter again on 9th of June. Okay. 9th of June. 2 weeks is over then. 9th of June 2026 at the top of the list. In the meantime, the respondent number 7 shall file their reply affidavit in opposition on or before 25th of May 2026. Liberty given to the petitioner to file reply thereagainst on or before 5th of June 2026. Interim order passed earlier shall continue till the next stage.
God bless.
What is it?
Due petition on last occasion, consider Satra Mikal over the directed to filing affidavit. Getting Malap, still the Malap,
Your Lordship, they've brought on record the fact that they are working with NIPCO.
Then
Your Lordship, on the last occasion, if Your Lordship recall, this was a matter with regard to Tipamuk project.
I know that.
Yeah, so they have brought on record that they are working with NIPCO. Your Lordship, we have verified, yes, they are working in a different project.
So you are going to consider it.
Will consider.
And to whom did I direct to consider earlier?
The chairman.
Earlier, whom did I direct?
NSPC.
NSPC.
That
No.
question may be.
Earlier, I directed to manager of the respond number 5. Who is respond
Yes.
number 5? Okay. Okay. The heard Mr. So-and-so, the learned counsel appearing on behalf of the review petitioner, Mr. D.
And 234.
Senapati appears on behalf of the NEPCO. Mr. So-and-so appears on behalf of the NSPC. The present review application has been filed seeking a modification. The present application has been filed actually seeking a modification to the direction so passed by this court to the judgment and order dated 8/8/2023 passed in WPC number 934/2011, whereby there was a direction issued whereby this court had granted liberty to the petitioners to submit a representation before the chairman and the managing director of the respondent number 5. That is the managing director of the NHPC. It is the case of the review applicants herein that the directions ought to have been granted. Or liberty ought to have been granted to the petitioners to submit the representation before the chairman and managing director of NEPCO. Inasmuch as NEPCO, it is under NEPCO where the petitioners are still rendering their services. Pursuant to orders, certain orders being passed by this court, and more particularly the order dated 5/3/2026, it has been ascertained that the petitioners are, the review applicants, oblique the petitioners are actually working in the Deepa
Turial hydroelectricity project.
in the Durial Turial
Turial.
hydroelectricity project of NEPCO in
Mizoram.
in Mizoram. So considering the above, it is the opinion of this court that the interest of the review applicants would be better served if the representation is served upon the a representation is filed before the chairman and managing director of NEPCO. Accordingly, the directions so passed at paragraph number 13 of the judgment and order. Accordingly, the observations and directions so passed at paragraph number 13 and paragraph number 13. Now, in the directions so the liberty so granted to the petitioners to file representation before the chairman and managing director of NHPC stands modified, and the liberty is granted to the petitioners, the review applicants of the petitioners, to file representation before the chairman cum managing director NEPCO. The instant order shall be a part of the judgment and order passed by this court dated so and so in WPC number so and so. The instant application stands accordingly disposed. Now, being a better case, take out the ISRO judgment. ISRO, look into that ISRO judgment and now draft your written statement, your representation in that manner. Trying to help you, don't ask further questions. Yes. Raman Properties. What is this? Oh, Mr. Srivastava,
So great.
you are not completed with these matters.
No, not unfortunately.
Then,
Because they are not coming Willard on dates. I'm
Who?
coming from there.
what are you asking here?
Millard, there is a number 2, Millard.
You are challenging some orders.
No, not order, Millard. A bill, Millard. Your Lordship may see just page number 43, and that clarifies everything, Millard. Page number 43, bill date is, Millard, 8/7 or 37/2021. And kindly see below the surcharge for the period June 1991 to 2005 for late payment. So that means during
Mr. P.N. Goswami, Mr. P.N. Goswami, are you not the standing counsel of the APTCL also?
My engagement is as additional agent. I do. This is
Anyway, this is the case of APTCL.
Yes.
Ask somebody to. Nobody is appearing here. Oh, here some beach order is appearing. Is not here.
in the country.
Is an interim order also? Huh?
I'll check now.
Interim order
entry
also.
order has not been complied.
Huh?
Entry order has not been complied.
What is there? Till
They-
then, no coercive measures.
No, Millard, I just kindly see the second page. Mr. Sharma, second page of the order, Millard, second para. Mr. Sharma, learned standing counsel, accepted the submission of the learned senior counsel for the petitioner in respect of the representation dated so and so. And as per telephonic instruction, the respondent APDCL is going to consider the said representation called DTDIPNA under the surcharge waiver scheme. This was a promise made before the Honorable Court, and this has not been complied.
Anyways, what is your case?
Yes, page 43.
No, what is your case in brief?
In brief, the claim of the Electricity Department is that during the period of 14 years, starting from 1999 to 2005, on several occasions probably, because they have not specified on how many occasions, I made delayed payments. So how many occasions I made the delayed payment is not specified, For how many number of days of delays were there, that is not specified. How did they calculate the interest?
Srivastava, what are you challenging?
I am challenging, this was challenged under section 56(2), and also because of anomaly of the
What are
demand.
you challenging? What are you challenging here? Defaulter notice,
Yes,
Annexure 16.
yes, yes.
What is it? Please take notice that true energy amounting to so and so unpaid in your account. You are hereby notified that unless the bills are not paid from the so and so, we shall reluctantly be compelled to disconnect the power. Now what happened?
Nothing.
Disconnected power.
No, power has not been disconnected
what
because
is
we
that?
paid the money,
Huh?
as per section 56, the minimum money which is required for no connection, that we paid. Then it is continuing, because there has not been hearing, and this the claim that they are making under page 43, is changed in their the reply, Kindly see their reply page, para 6, Their affidavit para 6. It is completely changed.
Yes.
So this claim does not
Is that a bill
Exists
of
today
so and so
also.
towards energy?
Kindly see page,
Upon any for the period from so and so to
I know the bill is changed. That the deponent most respectfully states that a bill of an amount of 6,22,000 towards energy charges was raised by APDCL upon petitioner May 1991, the period between 1989 and 90. And in that bill, it says that I defaulted from 1991 to 2005. Here he says that default is between 1989 and 1990, only 1 year. And even this is not clarified that on how many
No,
occasions.
this is a different amount.
And this is a different amount.
Then,
So this claim is different than the
so
bill
what are
amount.
you challenging? Page Annexure 16.
Recalling of that bill.
You see, Mr. Srivastava, you should be going to that alternative disposal range. There's some consumer forum, they have it. Why
No,
you
Milord,
not going there?
I have one order.
Don't trouble this court.
No, I'll not
Mr.
trouble, Milord.
Srivastava.
Kindly just consider
Because
one.
of these type of matters, we are not being able to take up your main matter for disposal.
Milord, kindly just accept one order of Honorable Supreme Court, and then I leave it to your lordship. One order of the order.
You are saying on the question of limitation
Yes.
that you have to file a suit not by way of disconnection. Isn't it your case?
No, because disconnection has not happened because I have paid the initial amount that was required
So
to be
what
paid.
is the Supreme Court say?
No, Supreme Court says if can be disposed by the Honorable Supreme Court, Honorable High Court, then it can be disposed by. It can be disposed because no facts are involved in it because they have not given any paper, any calculation even. So no facts are involved, only point of law. After 15 years, whether a bill can be raised, pertaining to 1989 and 19 as per para 6 and pertaining to 1991 to 2005. So section 56(2), subsection 2
So that is
of the Electricity
That
Act.
is the Supreme Court judgment.
Yes.
Wherein the Supreme Court says that you cannot disconnect, but however you can initiate proceedings for before the civil court. That's the law.
My lord.
Can you?
But,
Then also, why should
May I
I-
just read one, your lords? I'll take just
Then
1 minute of more of your lordship and then conclude.
For Supreme Court to look into it.
Yeah.
Where is the judgment?
My lord, in fact, your lordship also had the occasion to pass judgment in a similar matter.
Regarding sending for alternative.
No, not on,
No,
not on
this
section
alternative
56.
would not do. There's a bar, means because of the Supreme Court says the 56(2) cannot be resorted to. Yeah. this is the-
Para 14, and I read, my lord, from after from 8 lines.
Para?
Para 14, my lord. I read after from 7th line. The existence of an adequate or suitable alternative remedy available. Lordship, para 14 my lord. Para 14? Yes. क्या दे दिए? No, that is a wrong one. my lord. Excuse me.
No. There is another, yes, this one, the recent,
SGS.
this assistant engineer.
No, my lord.
Yes.
SGS. I'm referring SGS.
No, this one. Yeah. This judgment.
Electricity, my lord.
Electricity. One. This is the judgment very
So
insane.
electricity para 10, 11
No,
and
no,
12.
no. However, does not preclude the licensee from raising a supplementary demand after the expiry of limitation of 2 years. It only restricts the right of the licensee to disconnect electricity supply due to non-payment after the period of limitation of 2 years has expired. Nor does it restrict other modes of recovery which may be initiated by the licensee for recovery of a supplementary demand. Applying the aforesaid ratio. This is being done on the basis of the other judgment of the Supreme Court in the case of caustic industry. Isn't it, Mr.?
My lord.
That- this is the
was-
law.
Yes, my lord.
This is the law. What is the other law? What laws you are bringing before this court? We dispose it of in this terms of this later, it's a new judgment. Assistant Engineer D.I. Ajmer Vidyut Vitran Nigam Limited and another versus Rahamatullah Khan alias Rahamjula. Oh, the matter is covered.
My lord, one last.
Including a judgment passed by me also.
My lord.
Hooker Bank.
My lord.
Oh, we'll cover it.
Paragraph number 13, my lord.
Number 619. So they can go for a supplementary demand
Yes,
and then do whatever may be.
Yes.
But they cannot do it in this.
We can
Yes.
assist.
there is one last point.
No.
Para 13, one line.
Oh.
It says that limitation can be assailed under section 56(2) if there is a bona fide mistake or my lord, error in raising the demand. But kindly see the order, the demand, my lord, itself. It says that AG audit detected that in 2007 and 8, and the demand was made in 2021. So it is a violation of that also. That same order, my lord, para 13. Para 13 of Honorable Supreme Court order. Additional or supplementary demand after the expiry of period of limitation prescribed therein in case of a mistake or bona fide. So the bona fide error and mistake was detected in 2007 and 8 by the AG audit, and bill is raised now in 2021.
You are referring to Mahavir Kishore. Yeah, the Supreme Court also deals with it. As per section 17(1)(c) of the Limitation Act 1963. In case of a mistake, the
Yes.
limitation period begins to run from the date when the mistake is discovered for the first
Correct.
time.
Absolutely.
In so and so.
Yes.
In the present case, the period of limitation would commence from the date of discovery of the mistake, that is 18/3/2014.
Yes.
The licensee company may take recourse to any remedy available in law for recovery of the additional demand, but is barred from taking recourse to disconnection of the supply of electricity under subsection 2 of section 56.
My lord, kindly see the bill for
It's
once.
okay. I understand. This is how we allow it.
No, that is correct, my lord. This proposition correct, but the bill is raised in 2021 when the mistake was detected in 2007 and 8. That is my last point, my lord, and only point. Page 43, my lord, Annex 2.
Page 40.
43. 43, which is the bill, my lord. The
Ah.
bill that they have raised. Kindly see below, my lord. Total current demand, audit period 2007 and 8. As per AG audit period 2007 and 8. It is, they have written, my lord. As per audit period 7 and 8. And you are raising a demand of 2021. So it was detected in 7 and 8.
So you mean to say that they will raise the question of limitation and I should decide now? They are yet to raise that issue.
They have not raised that issue. They have not issued a supplementary demand, my lord, as per this.
We are here to stop it
Yes.
here itself.
So your lordship may just declare that bill which is that doesn't exist. This bill 43.
No, why
Because
would I-
at para 6 they have changed.
No, this is, you are challenging what?
This bill only. This bill only.
You are challenging the bill.
Only bill. Yes, that's it. And they have changed
27.
that at
No,
para
you
6.
are challenging 27. Where is the 27? Bill dated
This is the 27, bill date 27/2021, my lord.
Where is
Page,
27?
page 43.
Page 43.
Page 43, left side, my lord, date of bill, 27/2021.
No. It is the bill date. You are
Yes, my lord.
challenging this one.
Yes, my lord, this one. Kindly see.
And why you are referring to for 57?
No, page 43, my lord, annexure 2, date, bill of date is written 27/2021, my lord. Kindly see. Left side, my lord, top corner, left side.
Ah.
27/2021. The same bill I am assailing, my lord. Because this bill does not exist, they have changed the demand into in their affidavit.
So they are making a supplementary demand.
They can make. They have not made any supplementary demand, but as per their affidavit,
This
there
is
is a
a
supplementary demand.
This, my lords, what my learned friend is referring to, the period of audit is 2007-8, but the report by the audit was submitted in 21. We have said so on affidavit on note.
Where is that?
In 21, as soon as the report was submitted by the audit, we raised this supplementary demand. That is under challenge in this petition, and the grounds laid, your lordship, is violation of section 56(2) of the Electricity Act.
No,
Which is-
no, this is understood. Okay, this is 27/2021.
My lord,
Now kindly come to page 57.
my lord. My lord.
Yes.
Here you refer to some other bills.
This,
What is this bill?
Because there is no area, my lord.
this is regarding electricity. What is payable from them, your lordship? When there is a delay in payment, your lordship, there is a surcharge which has to be levied as per the tariff code. Inadvertently, though there was a delay in payment by them, they were allowed to pay in installments. The surcharge was not calculated on the amounts that were made payable by them. So when that was pointed out by the audit in 2021, though for the period of 2007-8, a supplementary bill was raised for the period for the amount of surcharge. Now they are saying that this is in violation of section 56(2).
But my lord, this bill does not say that there was any instruction from AG audit in 2021. It only says that as per the AG audit 7 and 8.
Audit
No,
period is
Mr. Counsel, my question is, are you now asking this court to declare this document annexure 2 to be bad?
Yes, ma'am, because as per para 6.
Why should I?
Because as per para 6, the demand is different. And this demand is different. Para 6 of their reply, my lord. Kindly just come to para 6 of their reply and keep this, my lord, before, and then see the both the demands, my lord.
No, can you come to para 7?
Para 7, yes, ma'am. Of their reply, my lord?
Yes.
Yes, ma'am.
As per the tariff order, so and so is entitled to raise supplementary demand of the consumers for so and so. As such, the APDCL ought to have raised the surcharge demand for the period from so and so. However, owing to mistake and bona fide, the APDCL failed to raise the surcharge bill on so and so. The said oversight was discovered by APDCL during an audit conducted in the year 2021. Immediately after the APDCL raised the year upon the petitioner for an amount of rupees so and so. So they are therefore explaining the mistake.
Correct, ma'am.
Now,
Correct.
they are yet to take an action on the basis of this. They have made the bill. The fact that you cannot be disconnected is not an issue.
Because I have paid, my lord. As
No,
per law also, they
No,
cannot.
as per law, you cannot be disconnected.
Yes.
But
yes.
they let them initiate process. Why you are here asking that? They are only raising a supplementary demand. Now, whether it can be raised or not, whether these are questions of facts, why should I now decide? Therefore, my question is, let them initiate. Then whether that would come under 17(1)(c) or not is a question which you can raise in any proceedings where they initiate. My question is that you are putting your leg out there and asking the spade out there. He's throwing the spade. You are just putting your leg out there.
There is still a legal point.
What is the
If
legal
I
point?
made the point, if the demand was of 1989 and 90 or 1 year, they have stated at para 6. There was delay, no? Delay payment was made in 5 and 6. So even that amount that was paid,
They say
that is a
that
dead
while,
asset.
while doing so,
Yes.
they have made some audit. The
Yes.
audit report was submitted for the year 2007-8. They made some audit, and during the audit, it was found that, which was submitted in the year 2021, that this amount has been actually the surcharge which should have been paid.
Yes.
Now, this surcharge, immediately they have made the supplementary demand.
Yes.
Now, for that amount, obviously, they cannot initiate an 56. 56, they cannot take recourse to 56.
Any other, not as per Supreme Court order.
Huh?
Any other recovery, mode of recovery they can initiate.
Take.
Yes.
They can.
Yes,
Let them take.
Yes, I'm on the last point. I 100% agree, my lord. Your lordship may pass an order now. I'm only saying that if the delay was made between 1989 and 1990, that is 1 year, and payment was made in 5 and 6, then that demand was already a date claim. So even if I voluntarily paid, because of many reasons, I know why, but I'm not going to that. Even if I paid, that was a date claim. They are charging interest on the date claim. This is my last submission, my lord, your lordship.
They say that we are required to impose a surcharge if
Yes.
there is a delay by 1.5%
My
or
lord.
something. Now, whether the surcharge is proper or not, whether it is delayed or not, let them prove it by
lord,
mistake by
I-
initiation of a proceeding.
I leave it to you.
Why should you? I today say not to do when they are not initiating a proceeding. Let them initiate some proceeding.
When I came,
You-
my lord,
you are
that time my
liberty-
electricity was cut, and I made the payment. When I came before your lordship, my electricity was cut because of this. Without
No,
speaking anything.
so therefore, my question is,
Yes.
they cannot resort to 56.
They cannot resort to 56.
So they cannot, on the basis of that bill,
Yes.
resort to 56.
Yes.
So
Yes.
therefore, that declaration, I'm going to give it to you.
I'm so grateful.
But as regards the other thing,
Yes.
this court is not interfering
Yes,
with that.
yes, yes.
However, all your liberty to raise as regards that such demand cannot be raised at
Yes.
a late stage,
My
it will
defense
be
before,
open
yes.
when they initiate any proceedings.
Yes.
That's-
I'm so grateful.
Yeah.
I'm
Wait for some time, let me come back.
okay. Also be part of it.
Hmm?
There is a direction by this honorable court on the first day when I appeared. So that may also be part of your lordship's order. First day's order, which says that in view of the same, the representation should also be considered, my representation for waiver. This was a direction by this order.
I'm not going to pass with that word.
Okay.
After you are taking a decision from me, the court is not going to pass an order that kindly consider them.
No, I just referred because that is the
If you
direction of
want,
this honorable
you,
court.
you can do one thing, you can withdraw the petition and.
No, Lord.
You-
Your lordship may dispose of it on the terms. Other terms. Grateful.
In the last 5 years, I have only passed 2 or 3 orders as directing consideration of representation. And when I pass this order for consideration of a representation, I follow it up with a very specific order as to how to consider. I'm not going to ask
Okay.
them to consider.
It's a general.
But the moment I'm asking him to consider, you are again putting yourself in more problem. They will come up and with many other things. Let them initiate any proceedings, then you take it up.
Absolutely. Grateful.
Heard Mr. A.K. Subhastup, the learned counsel appearing on behalf of the petitioner. Mr. K.P. Pathak, the learned standing counsel. For APDCL, appearance for the respondent authorities. The present appeal, the present petition has been filed by the petitioner. Challenging the bill issued by the APDCL dated 2/7/2021 for an amount of rupees 18,66,000. And further, the disconnection of the petitioners and further the action of disconnection resorted by the respondent authorities. Which as per the petitioner was in gross violation to section 56 of the Electricity Act 2003. The brief facts which led to the filing of the present writ petition are that the petitioner is in the business of hospitality, owning a hotel in the name and style of Hotel Dynasty, situated in Gauhati. The petitioner has a connection provided by the epidicial authorities and the consumer number of the petitioner is 006 also Soita 0373. It is the case of the petitioner that the petitioner, since establishing its hotel in 1984, have been regularly paying the bills raised however, out of the blue, an amount of rupees 18,66,000 was demanded on account of some purported surcharge for the period from June 1991 to July 2005 on the basis of a purported AG audit period 2007-08. It is the case of the petitioner that there was nothing due, no amount payable during the period from June 1991 to July 2005. For any such purported late payment, nor a demand was made by the respondents during the period impugned or any time after 2007-08. The petitioners have also enclosed to the petition the bills for the last 2 years, wherein there has been no reference to any late payment surcharge due from petitioner company. However, on 22/7/2021, the petitioner received a communication to make certain payments within 15 days from the receipt of the said letter or face disconnection. It is under such circumstances the petitioner approached this court by filing the present petition. On 23/7/2021. The learned coordinate bench of this court, by an order dated 4/8/2021, issued notice returnable by 3 weeks and also directed the respondent APDCL to dispose of the representation submitted by the petitioner dated 17/7/2021 under the surcharge waiver scheme within a period of 3 weeks. Further to that, the learned coordinate bench directed that no coercive measures, more specifically disconnection of power supply to the premises of the petitioner company, shall be carried out in respect to the bill dated 2/7/2021. The record reveals that in pursuance to the affidavit petition being filed and notice issued, the respondent authorities had filed an affidavit in opposition on 21/3/2025. The respondents initiated, contended that the petitioner has an alternative and efficacious remedy available. Thereby to approach the Consumer Grievance Redressal Forum. In addition to that, it was mentioned on merits that a bill for an amount of rupees 6,22,000 towards energy charges was raised by the APDCL upon the petitioner in May 1991 for the period between 11/4/1989 and 11/10/1990. The said bill was raised pursuant to meter testing and an inspection division report in July 1990. The petitioner thereupon made payment of an amount of 6,78,000, which included 56,000 towards surcharge in installments after an inordinate delay during August 2005 and May 2006. It was further contended in the said affidavit in opposition that as per the tariff orders issued by the Assam Electricity Regulatory Commission, read with clause 6.3.15 of the AERC Electricity Supply Code, supplementary demands can be raised upon the consumers towards surcharge at 1.5% for the delay in making payment towards the bills raised by the APDCL. And the bill which was raised in May 1991, the payment was made sometime in the month of August 2005, during the period from August 2005 and May 2006. There should have been a surcharge raised upon the petitioner. However, owing to mistake and a bona fide error, the APDCL failed to raise the surcharge bill upon the petitioner, which came into light after an audit being conducted in the year 2021. Immediately thereafter, the APDCL raised the bill dated 2/7/2021 upon the petitioner for an amount of rupees 18,66,000 to the said affidavit in opposition. An affidavit in reply was filed by the petitioner on 22nd of January 2026. In the said affidavit in reply, the petitioner raised the issue as regards the competence of the petitioner to raise the bill of surcharge in terms with section 56 bracket 2 of the Electricity Act 2003. First, this court have also heard the learned counsels appearing on behalf of the parties. Whose submissions were in line with the pleadings, with the respective pleadings. And as such, for the sake of brevity, this court is not repeating the said submissions. The issue involved in the present proceedings are twofold. First, whether the respondent authority can resort to section 56(2) of the Electricity Act 2003 to disconnect the electricity to the establishment of the petitioner on the basis of the bill dated 2/7/2021. Second, whether this court is required to interfere with the bill dated 2/7/2021. At this stage, this court finds it very pertinent. As regards the first issue, so formulated herein above, this court finds it very pertinent to take note of the judgment of the Supreme Court in the case of Assistant Engineer bracket D1 bracket close Ajmer Vidyut Vitran Nigam Limited and another versus Rahamatullah Khan alias Rahamjullah, reported in 2020 4 SCC 650, wherein the Supreme Court specifically dealt with the issue as to whether resort can be taken to disconnection in view of the provisions of section 56 bracket 2 of the Electricity Act 2003. Paragraph 6, 6.3, 6.4, 6.5, 6.6, 6.7, 6.8, 6.9 being relevant are reproduced hereunder. From a perusal of the above paragraphs, from the law laid down by the Supreme Court in the aforementioned above quoted paragraph, it would be seen that a proviso to section 56(1) carves out an exception by providing that disconnection will not be effected if the consumer either deposits the amount under protest or deposits the average charges paid during the preceding 6 months. Further to that, subsection 2 of section 56 provides that notwithstanding anything contained in any other law for the time being in force, no sum due from any consumers shall be recoverable under section 56 after the expiry of 2 years from the date on which the sum became first due, unless such sum was shown continuously recoverable as arrears of charges for the electricity supplied, nor would the licensee company disconnect the electricity supply of the consumers. In the present proceedings, it would be seen, and more particularly, a perusal of annexures 3 to 14 to the petition, which are the bills, which are the bills, which are the monthly bills raised by the petitioner, raised by the respondents, who show that there was no reference to the said amount of rupees 18,66,000 as the surcharge. Under such circumstances, applying the law laid down by the Supreme Court in the above quoted judgment, it is therefore the opinion of this court that by virtue of section 56(2) of the Electricity Act 2003, the petitioner, the respondent authorities, on the basis of the bill dated 2/7/2021, cannot disconnect the electricity connection to the establishment of the petitioner. The above, therefore, answers the first issue so formulated above. Formally. Next. The second issue, which is as to whether this court is required to interfere with the bill dated 2/7/2021. The answer to the same can also be found in the subsequent paragraphs can be found at paragraph number 7, 7.1, 7.2, 7.3, 7.4, 7.5, 7.8, 9, 9.1, 9.2 of the judgment in the case of Ajmer Vidyut Vitran Nigam Limited, and the said paragraphs being relevant are reproduced hereunder. From a perusal of the above, from the law laid down by the Supreme Court in the above quoted, from the principles laid down by the Supreme Court, as quoted above, it will be seen that the period of limitation of 2 years would commence from the date on which the electricity charge became first due under subsection 2 of section 56. This provision restricts the right of the licensee company to disconnect the electricity supply due to non-payment of the dues by the consumer unless such sum has been shown continuously to be recoverable as areas of the electricity supply in the bills raised for the past period. It was, however, observed by the Supreme Court that Section 56(2) do not preclude the licensee company from raising a supplementary demand after the expiry of the limitation period of 2 years. It only restricts the right of the licensee to disconnect electricity supply due to non-payment of the dues after the period of limitation of 2 years had expired. It also does not restrict the other modes of recovery, which may be initiated by the licensee company for recovery of a supplementary demand. The Supreme Court also took into consideration in the said judgment Section 17, bracket 1, bracket small c of the Limitation Act 1963. Which pertains to the limit as to when limitation period begins to run from the date a mistake is discovered for the first time. At this stage, it is very pertinent to take note of that as to whether at this stage, this court finds it very pertinent to take note of that as on date, there has been no steps taken by the judicial authorities to recover the said amount in a manner which is provided under law. The petitioner obviously would have the liberty to raise objections if any such recovery, any such measures are being taken for recovery. By pointing it out that the limitation period had expired, had long expired, including the grounds which have been taken in the instant petition. Under such circumstances, at this stage, it is the opinion of this court that the interest of this justice would not be in the interest of justice to set aside the bill dated 2/7/2021 with the observation that the said bill under no circumstances can be used for disconnection of the electricity of the petitioner to the establishment of the petitioner. Accordingly, the instant writ petition therefore stands disposed of with the following observations and directions. Number one, the respondent authorities cannot disconnect the electricity to the petitioner, to the establishment of the petitioner, on the basis of the bill dated 22 or 2? 2/7/2021, which is annexure A to the present petition, and annexure 2, which is annexure 2 to the present petition. Number 2, this court have not set aside the bill dated 2/7/2021. Inasmuch as the respondent authorities have the authority to make the supplementary demand. The question as to However, it is made clear that on the basis of the said supplementary demand raised by the bill dated 2/7/2021, there cannot be a disconnection of the electricity. Push. Number two, liberty is granted to the respondents to take steps for recovery of the said amount, subject to being permissible as per law. Push. The petitioner herein, now, in the circumstance, steps are being taken for recovery as per the mode permissible under law. The petitioner would be at liberty to take all such grounds which have been raised in the present petition. Including any other defense permissible under law. See. There shall be no order for cost. That's the next paragraph. Before parting with the record, this court, for the sake of clarity, observes that the liberty so granted to the respondent authorities to initiate proceedings for recovery shall not be construed in any manner that this court had enlarged the period of limitation. So, simple matter, you are trying to make it complicated. And what the representing authority will do better? Hey, well, it is that Nandi.
Item number 10, my lord, the affidavit in
The
respect of.
file,
Yes, ma'am. Jamuna Modonga, we have filed, my lord. Item number 10.
it is number 10.
No, no, Friday. Friday. Kali numbering. Anyway, so my lord, herein, my lord, I have also incorporated 2 orders passed in 2 different PILs, my lord, wherein the issue of rehabilitation was remanded back to the government, my lord, to take a call as part
No,
of.
obviously, I cannot decide that.
So there is some land policy they can apply. If my lord peruses page 412.
I don't know about others, but one thing I've realized after sitting in the bench, one has to know where one's jurisdiction lies. I don't have the jurisdiction to direct them to settle any land breaches. I have the direction that to look into it if this, you are not taking an action in as envisaged in the law.
My lord. Just for your lordship reference, my lord, they page 412 of the affidavit. This was, my lord, done pursuant to the Honorable Supreme Court's order.
412,
412, it's a joint verification, my lord.
yes.
As regards the petitioners, these petitioners are before Honorable Supreme Court also. And it was found, my lord. We have made a chart, my lord, all these petitioners, my lord, residing inside reserved forest. And there is no record of revenue department, my lord. Then my,
Jamuna Mudunga.
my lord, Jamuna Mudunga. Then my lord, if my lord peruses, page 421.
That's the map.
That's the map, my lord. The yellow is the boundary. Sorry, green is the boundary. Yellow, this P1, P2, these are the coordinates. And my lord,
They are all staying in the boundary.
these blue are the petitioners staying inside the reserve forest.
Or these P1, P2, these are the coordinates.
These are the coordinates. We have also given a detailed coordinates, my lord, that my lord finds at page 460.
Or
460, my lord. This is the longitudes and latitude.
so these are the longitude, latitude.
Yes, and my
So
lord,
this is for Jamuna Mudunga.
Jamuna Mode.
Okay.
National lovers movement.
Huh?
National lovers movement judgment last occasion, my lord, indicated. Now, 2 things come up. My lord, there was a case where the state of Karnataka was inclined to de-reserve for de-reserve
And because of some policy.
policy up till
The interesting
1977.
party in that judgment, there are two parts. One is some portions they were wanting to give, and therefore that was done and it was upheld.
Well,
Certain portions they did not want.
yes,
And then the court say that even the central government on its own cannot do so.
yes.
In view of the
Section-
word starting, section 2 starts with a non-obstinate
Non-obstinate
clause.
So what I could understand, my lord, section 2, there are two authorities actually. First, the state has to act for propose de-reservation, then the concurrence of the central government.
Or
So-
in other words, the state has to move under 22.
Yes.
And in moving under 22, the state has to first take the concurrence of to give effect to the 22, the state has to take the concurrence of the central government.
Yes.
That is
Exactly, exactly. And there are actually two authorities. It has to start from the state. And there is a case, my lord, state of Assam is not, there is no such policy, my lord. We are against enforcement, my lord.
So
I think,
therefore, that judgment of the natural lover,
my lord,
it categorically deals with that portion also.
Yeah.
That when the state does not want it,
that it
under
cannot be
no-
done.
even the central government cannot.
Yes, my lord.
That's one paragraph, if I remember.
Paragraph 39, last part, my lord. This necessarily implies that where the state government had not taken any policy decision to regularize pre-1980 occupation encroachment of forest land, no order of regulation of such occupation encroachment can be passed without obtaining prior approval of central government in terms of so and so, as mentioned above, contains a non-obstinate.
Now, in this case, it is the forest policy, the pre-1980 we are thinking of. But
Yeah.
the question of regularization cannot happen.
Exactly.
The regularization can happen only with the central government.
When it does not.
So this forest policy may be there. It is after all, it's the policy of the state.
Yes.
It is not a law.
Yes.
It's a policy of the state. This policy of the state has to be then brought in by way of either an amendment to the Assam Forest Regulations or an amendment to the State Central Act or by some concurrence, something has to be.
Basically, guideline for the executive.
So otherwise, in order to give effect to clause 4.3.1, the state has to move the center also
Yes.
to give effect.
Exactly.
Unless the state does not move the center, there is no vested right upon it.
Exactly. And even if my state at any point of time decides to go for de-reservation, non-forest activity, that has to be my lord justified.
But that will only apply. I'm again saying 4.3.1 will only apply if you want to settle them within a reserve forest, then for central government comes into the scene.
Yes.
But if the state government, in terms of 4.3.1, wants to give them somewhere
Else,
outside,
then no issue.
then central government.
So that
has no
policy
business.
has to be confined to lands beyond the forest land.
Then there's no problem. So
Exactly.
as per 4.3.1, the state government can very well give them land to the outside the boundary,
Exactly.
maybe 100
And-
meters beyond, because these people are, some are residing. The forest department must have gone bankrupt with the earlier set of maps. It was
Yes, sir.
bigger, now it
Because
has
the
become
DFO was telling-
minuscule.
DFO was telling me, my lord, to do this mapping, my lord, use of drones. He has to draw bill, my lord.
But the thing is that you should maintain it in this.
Exactly.
Maps out
In
there.
fact, I have instructed to do this for all the reserve forest.
But here, can you see? These are those people who are inside. There are some outside also.
Outside.
You are outside. Anyway, some are inside or whatever it is. This is within the.
Yamuna.
Now tell me, what about the geographical coordinates of other matters in other matters?
We have also annexed
Where?
in the affidavit.
Can you give me the page number?
Yes.
Let us come to number.
Number, my lord.
Number to page.
My lord, item WPC 1615. I can note, my lord. Item number 9.
In fact, Mr. Goswami, that day I was thinking aloud. Now, sometimes what happens, just for example, let us take the case of Lambo. Lambo came on 1916 or 1922,
Right.
whatever. You have the map which is being, there is the boundary stipulated, section 17 notification concern. Once the section 17 notification take on, then you review. Because you see. Now kindly come to section 4
My lord.
of the Assam Land and Revenue Regulations. This chapter shall apply to all lands except the following.
Yes,
So reserve forest is out,
out, my lord.
land including any reserve consider
Reserve forest under law.
the law for the time being, any land which the state government might exempt. So
Yes.
reserve forest is out.
Out.
If the reserve forest is out, there cannot be a settlement to be
Yes.
granted by the revenue.
Yes. Cannot,
There cannot be a conferment of right. Now, if there is any conferment of right on the basis by issuance of a patta by the revenue union, if it comes within the boundary,
that will be non-esteemed law, my lord. That's settled, my lord.
that would be contrary to the Assam Land and Revenue Regulations.
Yes.
One. Number two, it will also be in contrary to 17,
Yes, my lord.
because no right can be
No
claimed
right can be.
under the Assam Forest Regulation,
Yes, my lord.
unless the state exercises the power under 22. Once the state exercises the power of 22, would have been exercised prior to 1980.
Yes, maximum possible is 1980.
1980, they could have exercised the power by making it de-reserved. But for de-reserving also, you require notification.
Yes.
Now, without that notification being there,
There
can
cannot,
there be a issuance of a patta?
no. Even if, my lord, assuming wrongly or rightly patta was issued, it will be time specific, my lord. Once that time is gone after 1980, again that section 2 procedure is to be followed, state and the central government concurrent.
No. That is if the forest department does.
My lord.
I'm not on that.
If the revenue grants,
The revenue was.
that
Let
is
us
void
assume
ab
the
initio.
revenue has done.
That
There are
will be,
many cases.
that will be void
You
ab initio.
find it where the revenue have encroached upon the lands and say that, okay, we have granted. Because in some litigations I could find out wherein there is always a process. Here also they
In
say,
Amsang Reserve also,
here also they say, in these cases also they say that the revenue, these are revenue lands.
yes.
You have also your case that these are revenue lands, this does not fall under the reserve forest. Now, if it falls with, that is why the Supreme Court say, while forming the committee, we have the revenue people also.
Like this. Yes, my lord.
Now, the question is, after the revenue, whether it is there or not, once it is being found out on the basis of geographical coordinates, which is has the accuracy to a extent of around 6 centimeters, and it falls within the the reserve forest, then by virtue of 4, revenue is out.
Revenue grant.
Once revenue is out, then the state could have an only be reserved under 22. Without 22, nothing happens.
Nothing.
And after 1980, 22 cannot be permissible without the central government.
Section. Yes. sir.
So under therefore the revenue, the land, if it is mentioned even by the revenue to fall within it, but if it goes outside the
Exactly.
geographical coordinates, which the fact finding authority has done it, inside, then obviously nothing remains.
In respect of Kalapahar Reserve Forest, what we found, my lord, that when the forest was notified,
How
Right.
what's happened to that? I passed some judgment in that also.
yes, my lord. So that
I
has been,
asked the people to be vacated
Yes, they have been vacated, my lord. Some lands were allotted, some were allotted with land, some were vacated. They preferred a review, my lord. My lord.
How lands were allotted?
Government land, my lord, normal revenue
Outside
land,
land.
outside that.
Not inside.
There was a direction from your lordship to allot, if possible to allot
Yeah. Outside.
outside. So
It
they
is,
preferred an
I
appeal,
think
my lord.
Mr. M not appeared.
Yeah, they preferred an appeal, then against that appeal order, they preferred a review, all dismissed, my lord. Therein, my lord, what we have seen, my lord, the revenue, it was prior to the 17 notification, it was the revenue land. Once the notification was issued, the correction of map by the revenue was not done. They were maintaining the same map, same documents.
Yeah.
Exactly. That has also happened in several cases, my lord. But here, these are very old forests, my lord, 1915, 1918.
Now there is another forest where I remember recently it was being very much shown out there that it has now, it was some hill where the land was acquired and then made a reserve forest. What is
Then in that case, my lord, what will happen if it is
some hill? It was shown. This was the propaganda also. It was shown that
Is
hill
it my
which was
Gauhati
barren,
reserve?
now it has had all trees and all.
Is it Gauhati Reserve Forest?
I think maybe it was a hill.
Yeah.
There was nothing out there. Now, after 2-3 years, some trees are growing or something. That was being shown as to how the state of Assam has been progressing for the last 5 or 10 years.
Item number 9, my lord.
Okay. Can you ask your junior to give me the photocopy of that page and mentioning in which line? Because then it will become easier.
I'll do one thing. I'll mention all the cases, forest, affidavit page indicating longitude and.
No, only, yes, only, give me a page, that page, that coordinate page. Just for this, here you are having a coordinate page.
Item number 9, my lord, coordinate page. I will write it down, my lord.
Yeah. No, you write it, then give it to me.
Yes.
Wait, here, 200 and.
Item number 9, my lord, page 566.
And what are the other orders you are referring to here?
But the PIL orders, my lord.
PL for
PL for rehabilitation, my lord. Page 441 and 445.
Now tell me another thing.
My lord.
In Assam, in the Assam line policy,
My lord.
you have taken a decision to allot the land only to those indigenous people.
Well.
Indigenous landless cultivators or whoever, indigenous. How do you identify that?
I have
No.
take, but it's not defined.
So no, nothing. So therefore, 2019 land policy is on a different thing. Yes, you may give them the settlement area, but you do not override the Assam forest policy of 2004, which is also there. So as regards those people who have been allowed to remain prior to 1980 by authority given by the competent authority, then that should be the consideration.
Yes.
Outside,
For that,
outside the reserve forest. That should be the consideration, not the consideration, the parameters which have been laid out in the Assam land policy.
so in that case, my lord, the state should be guided by the land revenue regulation.
Understood.
Not the policy
Because
of
the
19.
settlement has to be made on the basis.
Exactly.
But mainly because of the fact that some parameters are not met in terms with the Assam land policy of 2000, which is also a policy. But they do not override the Assam forest policy of 2004. So therefore, the parameter on which you are to choose that they should be given is subject to verification as to whether a competent authority prior to 1918 permitted these people to reside in the reserve forest. Obviously, they will be out of the reserve forest, but they have to be given somewhere else.
Exactly.
Isn't it, Mr. Guya?
In fact,
Yes.
my lord, my
I
instruction.
think that should be, that is your submission also.
In fact, my instruction is that, my lord.
I am thinking some other way also.
Okay, let us we'll hear you.
In fact, my instruction is that, my lord, the fresh forest policies in the draft stage, my lord, should be published within a week or two.
It's okay.
But as of today, my lord,
Policy is given within a week or so, that is a different thing, but We have also seen this land policy.
Yes.
And if you see the difference between this land policy and the 86 land policy, yes, there has been certain aspects which are being touched. Otherwise, other things remains the same mostly. Taking into account, just for example, clause 8. See there also, here 8. These are bricks. Exactly the same words. Other remains the many of the aspects, how the periodic patta and all these things. Yes, now this time what has happened, the periodic patta emphasis is being given. Earlier also, 86 policy also gave that emphasis. But you ask him to give it. This coordinates for this. Yes, Mr. Arvapudari, what do you have to say on your revenue business? And yes, before that, yes, you were referring to those judgments.
My lord, page 441 and 445.
What does he say? A week of mandamus or year should not be able to be able to the forest dwelling scheduled tribes.
441, if we turn to my lord 444.
No, the fact remains as regards the forest dwelling. Here the prayer, if you see page 442. Forest dwelling scheduled tribes or landless people, we are not concerned. Forest dwelling scheduled tribes, they are protected under the
Yes,
2007.
well, yeah, well, this is basically the, this honorable court has quoted
Because
the prayers.
I think you have also another, the forest department also I could see in their website, another rule pertaining to how you are going to tackle with these forest dwellers, as well as the scheduled tribes, how the manner in which you are going to do it. That is also
In
mentioned.
this case, my lord, none of the petitioners will come under section 296.
Then they
Page,
have also-
page 444, just in the concluding part.
For the petition is not to undertake and not survive. However, the prayer for rehabilitation results where the otherwise landing results for we have been evicted from the forest again requires representative. But tell me one thing. This operation which has been directed by the learned division bench. Wouldn't that be contrary to section 4 of the right to of the Forest Dwellers Act? Of the right of the forest is also known as the Forest Rights Act of 2006. Because Forest Rights Act 2006, more particularly section 4, starts with the word notwithstanding any other law.
Yes.
So therefore it overrides the Forest Conservation Act 1980, that what is mentioned in 2
Yes.
or anything. In respect to those persons who are forest dwellers having 75 years or who are scheduled tribes. So if it is a forest, the landless people would not come in, but
Forest dwellers,
dwellers,
they'll definitely come under the
then
purview of
because they are
296.
if any other law is made by the state, it will be affected by the repugnancy, because it's the Central Act. Anyway, that is it. Then the next one is.
445, my lord, 447. .447, last paragraph. In this item number,
The coordinates,
this coordinate, yes, my lord,
coordinate pages you just give it.
I'll give writing.
And these are the petitioners who are in the coordinate.
My lord,
And what is the last one?
map,
And what is this green area? Of the 464 is what?
464, my lord, in the middle right hand. That green is my lord Jamuna Moranga.
Oh, that one.
Yes, ma'am.
And same is here. Oh, this is Jamuna.
If we come to my lord 463,
So here, if we see, can you come to 463?
my lord. Inside this purple color, my lord, this yellow, entire is Jamuna Moranga.
Now, what is this purple line?
Purple line is my lord Jamuna Motonga map. my lord.
Motuga. So therefore, beyond the purple line is also some greenery.
Yes.
What that is also Jamuna Motuga. That has been reserved substance somewhere else.
Maybe my lord.
Because the reserve,
Encroachment is in the top, my lord.
huh? It's
Encroachment.
okay. But
Yes.
that is encroachment.
Yes, there is greenery beyond in the right hand side in the eastern part
Huh?
of the map.
No, now tell me why this is in the other map,
Well-
page 463 and 421. 421. I think it is a different map.
Well, 421 is my lord satellite map, my lord.
Huh?
421 is satellite map. This is the present condition of the forest. 421.
Huh.
But my lord, it produces the boundary. It's identical, my lord. But in the
Yeah,
other
it's-
map, my lord,
it's identical, but why the reserve forests have gone beyond that on the right hand side in the 463?
in the right hand side, my lord.
See,
421.
portion, you see,
It
the
is
map is still here, and here this area is also reserve forest. How it will become if it is outside the reserve forest?
463, my lord.
Huh? How is it possible then? But this is also a reserve forest, you are saying.
Maybe, my lord,
This is the map. These are the code name.
my
What
lord.
happens to this area?
But this is not reserve forest, my lord. This has gone because the word is the long, my lord. Jamuna Modonga Reserve Forest. Forest, what has gone beyond that map, my lord. But this is the coordinate.
Then that means this area is reserve forest also.
So beyond that, my lord, this purple color is not reserve forest. That is true for the other map of the 421.
Huh?
The pattern of the map, if my lord produces 421 and 463. In the eastern side, my lord, it is directly from P14 to P15. Herein also, my lord, P14 to P15.
P
Straight line, my lord, in the eastern part.
P14, P14 to
P15.
15 is okay. Now there's no problem with that. But I'm saying about, what about the above from P6 to P14? What is above that?
P6 to P40. Above is, my lord, beyond reserve forest, my lord.
So that is, but it is shown in this map at post 63 as the reserve forest.
No, my lord.
Yes.
If my lord produces P9, P8 and P9. The shape is same.
P8 and P9 is okay.
Then P10 goes down.
P10 goes down. But what is above P8?
Above P8, the map is 7, but the area is, my lord, not Jamuna Modonga.
But why in page 463, it is being shown as the entire stretch to be above P6, P8 and P9 and P13.
Well,
There's a reserve forest. How? it is?
above area is, my lord, only the word has come there, my lord. Jamuna Modonga Reserve Forest. Because of the length of the word, size of the word, it has gone beyond that, my lord.
Color is also green. my lord.
Maybe color is green, my lord. If we see that color, it's a normal political map, or if we see the present map of satellite map, my lord, page 421, this greenery is nowhere there, my lord.
420, yeah.
If my lord produces 421 for a moment.
There also it is not there.
421, my lord, will see there is no greenery, well, it's a satellite map. There are all human habitation.
But above that, just for example, above P2,
P2, my lord.
P3, or right hand side or east of P3,
Yes.
we have greenery.
A greenery in the, yeah, my lord. 421 map, my lord.
To the east of
But that
P3.
doesn't fall under the notified RF, my lord. If we see page 463.
Where there are trees, there is no RF. And when there is no tree, there is RF. Anyways, anything more, Mr. Musalu?
That's all.
Yes, Mr. Bhuya, what do you want to say?
Lord, the maps which has been realized by the Milord department. Milord, is a map has been recently or when it has been prepared, we are not sure yet, Milord, because I do not have got the opportunity. The affidavit has been received only today, it's come to my knowledge. So, Milord, at least the instruction which we are getting, we have some maps with the petitioners, Milord, wherein it can be demonstrated that they are outside the purview of the Milord, the notified user.
How do you have a map?
Milord, perhaps they have collected those things from the some official records, Milord.
How?
So RTI or some means maybe there. I'm not
Here,
sure.
there is no map, prepared
Mile,
to the
mile.
effect. You see,
But-
there
but-
are, you see, as of now, therefore I'm
Mile.
saying, can it still be put into
Mile.
this map? Okay, we'll hear again.
Yes, yes. Milord.
You take this book in the meantime and
Yes.
have a look at it. Huh? I'll just give it to you.
Yes, yes.
This I've taken.
Mile.
Have a look how maps are prepared.
Mile.
So there has to be a map of
Appear-
this.
Yes, yes.
Yes, Mr. Bhuya.
May I please? My Lord, I have gone to the relevant part of the provision which my lordship has referred, Milord. If my lordship allows me to read over the relevant part, Milord. For this, Milord, before reading, Milord, my respectful submission before my lord is that, Milord, if we are admittedly residing in a forest land, Milord, admittedly, Milord, after the 1980 Act, which is, Milord, notwithstanding anything, any other law, Milord, concerned that is there. So it will be very difficult for us, Milord, to remain therein, Milord. That is an admitted position, Milord. But before going that, Milord, my lordships, as it is a matter of eviction, we are residing therein from last 70, in some people I have got the records 80 years also, Milord. Now suddenly, Milord, if we are required to vacate or go from there, it will be very difficult to, Milord, start our life again, Milord. Entire families or the person concerns are involved herein will be, Milord, very difficult to restart again. So, Milord, therefore, Milord, to go into the very root of the matter, Milord, that whether we have to ascertain, Milord, whether the original map which had been created by the government, Milord, for the purpose of reservation of this land and to notify the area with a map, that is, Milord, is very vital, which my lordship says, Milord, referred to, Milord. Actually, I forget to bring into the notice of my lordship, Milord. I have gone for the provision. It is specifically says, Milord, that a map of the area proposed. That means, Milord, if I not wrongly understood, Milord, if an area is, they have decided to be a reserve forest. So proposal is required to be made with a map proposed to be reserved should be prepared by the by the forest officer for the approval of the forest settlement officer and should be signed by both officers when it is finally passed by them. The boundaries of the reserve originally proposed should be outlined with a dotted red line and the area finally recommended with a dotted green line. Other existing reserves in the neighborhood should have their boundaries outlined with a continuous green line. Areas excluded from the proposed reserve but within its boundaries should be surrounded with a dotted green line, and the areas in which zoom cultivation is permitted should be colored with a green wash. Paths and roads over which the rights of way are reserved for the public should be indicated by a ground broken line. The map must contain legibly written the names of all rivers, villages, bridges, etc., without exceptions mentioned in the settlement of boundaries and as far as possible of all those mentioned in the proceeding of the forest settlement officer. So, my lord, there is a detailed, my lord, procedure has been prescribed under the rule that when they are going to propose, it should start with a red line. Then when it is approved, my lord, that red line should be converted into the green line and the other procedure which has been prescribed. But my lord, till date, my lord, the forest department has failed with the notification, my lord, which was the map, which I am, my lord, we were repeatedly, my lord, urging before my lordship that the original map should be there, my lord, as per the provision of this rule. Till date, my lord, those maps has not yet been exhibited before my lordships for the satisfaction that yes, my lord.
I want to see.
My lord.
C, we are reading A.
My lord, where survey of India maps of scales not smaller than 1 inch is equal to 1 mile exists, use should be made of this. The forest officer should ascertain from the provisional survey officer whether map on 1 inch scale, if any, exists of the area in which the proposed reserve falls, and where such maps exist, the officer in charge of the Assam Traverse Party and the drawing office should be requested to supply the pentagraph enlargement to the 2-inch scale of the particular area with which it is required to deal. The forest officer should then supplement and correct this enlargement on the grounds as may be found necessary for this purpose. My lord, yes, it is here, my lord. C is also here. But my lord,
Finally come to 2,
my lord,
1, say D, 1 and 2. For reserve forests that have been notified but not mapped, the survey will enter the correct spelling in all maps and will notify the conservator concerned of correction to names which appeared in the notification, and amended notification will be issued if errors are numerous and blurry. So these are the manner in which the map is to be
my
done.
lord, my lord,
Now, therefore, the question is here
my lord.
that they have done it on the basis of the survey of India maps.
Survey of India map, my
So
lord.
therefore, they have on the basis of the survey of maps and then applying the same, which is also seen in some of the affidavits, they have put the survey of India map in some cases.
My lord.
And from there, they have applied that particular basis and then have come on the basis. Now kindly see the manner in which they have done it. It is kindly seen from here.
My lord, yes, sir. My lord, in the affidavit which filed today, my lord, I have gone through the averments which they have made in connection with the maps which relied on. My lord, starts at page 391, paragraph 4, my lord, the procedure part, my lord, which my lordship is referring, my lord.
Item 17, my lord, is more clear, my lord.
Kindly come to the page 453.
463, my lord.
Application, how it is done, 7.1. Kindly see 7.1, 454. What is the procedure for?
One. Top seat use, my lord. The reserve forest on account of its size approximately 2,859 acres under the present notified boundary after the 1957 and 1973 dereservation, and its compact rectangular orientation along with the south bank of the Jamuna River lies wholly within a single survey of India top seats, namely so and so, so and so. The top seat was obtained from the Survey of India and used as the geo reference layer for the present exercise. Because the entire reserve forest lies within a single seat, no mosaicing was required in order to present the boundary with a sufficient clarity relative to the dense cultivated and settled areas surrounding the reserve forest. The final map submitted with this report is produced at the enlarged scale of so and so. My lord, plotting of the notified boundary. My lord, whether this is the procedure they have prescribed or adopted. My lord, this is a part of annexure. Part 2, my lord, application
Yeah,
of,
this is very-
my lord.
Mr. Bhuya, kindly come to 7.2.
Yes, yes.
The boundary described
Plotting
in
of the notified boundary. Yes, my lord. The boundary described in the schedules to the constituting and addition notification read in the light of the consolidated pillar to pillar description contained in the December 1973 dereservation notification, which records each of the third boundary pillar by bearing and distance was translated into the digital polyline in GIS software. Each natural features reference in the schedules, the south bank of the Jamuna River, the Dikharu River, the Kalsara Nodi, the Ghunia Jan, and the edges of the cultivation of the Jamuna Gaon and Maudunga Gaon was identified of the geo-reference top sheet used as a control for the notified line. Milo.
Then how it is done? Field survey was undertaken.
Yes, yes, my lord.
to roads.
My
The
lord,
survey
my
team comprised of so and so survey experts, so and so. The field survey is two phases. The first phase, the team navigated to each of the boundary pillars identified for constituting an addition notification and from the consolidated pillar to pillar description contained in the December 1973 notification. Using the coordinates extracted from the geo-reference basement, the rover was placed over each identified pillar. RTK connections were served, received, and the coordinates of that pillar was captured and recorded. The recorded coordinates was then plotted on the top sheet and verified against the notified description. A joint survey of the GIS verified boundary was carried out with the Revenue Department officials as per the guidelines of the Digital India Land Record Modernization Program. In the second phase, the coordinates of each notice was also collected from the field finding. The survey confirmed that the notified boundary of so and so, as described in the constituting notification read with the consolidated pillar to pillar description of the December so and so notarial is traceable on the ground. Certain sections of the boundary have witnessed significant encroachment and several of the original boundary pillars have been obscured or partly damaged. These have been identified for reconstruction. The boundary plotted from the notification and verified by so and so and captured so and so with the revenue have been rendered in the final map submitted as annexure as a prominent purple line. Notified boundary as so and so. And this is how it is done. Then another aspect is if you see the other, there is this is there in this thing. Can you see the here? This is the geographical coordinates. Now, can you see the affidavit file in this case? This is another in this Abdul Khalik's case. Have a look at. Kindly come here to the affidavit profile, additional affidavit. Here you see at page 573. This is the Survey of India map, isn't it? Mr. Mr. Goswami? 573 is the Survey of India map. No.
571.
573.
579.
here it ends at page 570.
WPC
No,
16.
not this one. Before reaching those. In the 1615. After your additional affidavit, you have filed, no?
Hello.
Additional affidavit file 559, it starts with 559, 560, 561, 562 is the manner in which it is being done. Finally, see this. 563 is the how the collection is being done.
What?
Georeferencing of the notified boundary.
Yes, my lord. This is
The original the gazette here, you see from the earlier Jamuna Modunga, they had the original map.
yes.
They have mentioned it out there in that that aspect. They have mentioned that map. But here, if you see, in this case, kindly see in 563,
map showing this whole top sheet of G.
No. I think the pages are wrong with you. Mine says 563 is part one, general methodology for survey and digitalization of the reserve forest. Has anybody got it?
553. 553.
Yes, yes, it's 553 here.
This is how the collection
Yes,
of
yes.
primary records. They have
No, my lord, my lord, respectful submission before my lord is that, my lord, we are not disputing or denying that, my lord, the methodology which they have adopted or doing at this moment, my lord, is not in connivance with the prescribed procedure or the law which are required to be followed, my lord. But only my contention, my lord, is that when there is a notification is required to be made, my lord, then it should be followed by a map, which has been under the rules, Milord, which we have just read over, Milord. Now, under that rule, Milord, the map which they have originally created, we have not seen, Milord, till date. That map has not been produced before my lordships, Milord, for the. Now, Milord, if in comparison with both the maps, Milord, obviously, Milord, there may be some changes in the geographical and topographical area. Some forest may be there at that time. Now it may not be there, but the boundaries cannot be moved, my lord. It should be intact. As it has these notifications by way of a subsequent notification, there is no any additional annexures of the area has been annexed. So therefore, my lord, if we, my lord, within the my lord notified area of that but original map, my lord, then we have, my lord, very difficult, my lord, I am submitting and conceding, my lord, then it will be very difficult for us, my lord, that we can be allowed to remain in that area. But, my lord, if it falls within the revenue land, my lord, then, my lord, may kindly appreciate that as we are residing more than 80 years, now we have been decided to be evicted by chasing us out, my lord. That's the only thing, my lord, that if the original map can be produced before my lordship, my lord, and a comparison is made with the blue dot or the, my lord, the line which they have drawn now,
Mr. Mbuya.
my lord, my lord.
First of all, you see, this is a submission which you are making which holds no ground. And you are just making it for the sake of making it. I'm telling you why. In this case, if you see, things have advanced from time to time. Nowadays, you have various geographical coordinates to find out. At the time when the maps were made, these were used on the basis of Chinese and all.
Yes, yes, my lord. Manual manner, my lord.
And in fact, at the time when I still remember those matters, more particularly if you see the matters pertaining to Arunachal Pradesh, you'll find out. In Arunachal Pradesh, land belongs to the state people.
My,
There's no land belonging to the state.
yes, my lord.
So what happened? These lands are donated. Just for example, take the case of Pasighat. Pasighat, this land has been donated. And on the basis of that, they have prepared, there's no map, there's no particular map which is being there, but they have bounded with certain boundaries. This is how it has formed. Similarly, at the time when these reserve forests were made, these were made on the basis of identification of certain areas.
Yes, yes, my lord.
Because you have to understand what it was in 1878, how the boundary was made. Because at that point of time, you have also to understand, prior to 1878, you had the 1865 Act, but that 1865 Act was never applied to the state of Assam. But for the first time, after the annexation of the Assam by the Treaty of Yandabu, in 1878, first the Act was applied, and by applying 34, Section 34 of that, various notifications were carried out, which you find in one of these cases that there are various notifications and almost 30, 40 reserve forests have been made. These have been identified by 4 boundaries, although these could not have been done in this manner. But anyway, these have been identified with those 4 boundaries or 6 boundaries. Now, on the basis thereof, that it runs from this to this is being done. Thereupon, you will see these rules which I have given you, these rules were made in 1930.
27.
The rules which I have given you,
Yes.
these are made in 1930s
Well,
as to how it is to be done. So these are the rules which are made in terms with the 1891 Act, 1891 regulation. So at that point of time, they had prepared some map. But therefore, but be that as it may, the Survey of India continued to have those mappings. And therefore, you find, therefore I said, you find in C, 10C, it refers to, kindly look into if there are Survey of India maps, you first refer to them. And in consonance with this, they have this map. You also see at 563 the original sketch map accompanying the notification. So they have looked into those, superimposed with the, and also applied the Survey of India map. And on the basis of that, they have come up with the geographical coordinates. Geographical coordinates gives accurate information as to what are the actual boundaries. By chainage, there may be a difference around 500 meters or 600 meters can go this way or that way. In fact, if you see, if it was because of the geographical coordinates, you would come within the ambit of the reserve forest. And if it was not the geographical coordinates, taking into account the picture, these are people who are residing just on the boundaries.
yes, even some, blue lines, are the
Except a few who are very much inside. Most are all along the boundaries. It was not the geographical coordinates, then with the chainage, it may not be possible. It may go this way 500 meters or this way 500
we could
meters.
have saved Milord.
Huh?
We could have saved Milord.
It could have been saved.
Well,
Now, therefore, with things advancing everywhere, we have to now consider that they have done it. You have also understand that this court is a writ court.
no, Milord, well,
So therefore, if they base their decision on this, my
Right.
question is, now we have these geographical coordinates by which the entire boundary of the reserve forest is being marked. This is a very important stepping stones for conservation of the reserve forest. Once this is being done, what happens in the rest of the area, whatever happens, I'm not concerned. But inside it, it is not being protected with you, as against any other person also. Has to be removed from there.
but
If-
Milord, I am again submitting.
I,
Milord.
I I understand what you are going to
My
submit,
lord.
but that is the thing.
My
But
lord.
what happens at the end of the day? Therefore, I have got these geographical coordinates to insert these. Now, once becomes they have produced these maps now, giving on affidavit that these are the these are the geographical coordinates. So now this reserve forest will fall within this ambit with these maps, which are given from P1 to P15 or P17 or P27. These are the four or the boundary of the map. So now anybody within these geographical coordinates, if it is residing out there, that would be the reserve forest. Anybody outside, if they are no problem with that. But if there is anybody inside, they have to go out. I cannot go into the aspect as to whether you can look into this here. Anybody you have any proof to the effect. In fact, it will be next to impossible also. You have to also understand. I also understand the thing that you may not be having many documents to the effect.
No, Milord,
Obviously, you may not have those access to all these documents also. These are various other documents which are there, which they have it with them. So these things are there, but you can't help it. But at the end of the day, Mr. Bhuya, one has to look into it that whether the reserve forest is there, this is a must which is there. Apart from that, I am going to therefore look into it as to how you can be protected if you are prior to 1980s, as you are saying, and have been allowed by a competent authority to reside out there. Then obviously this will happen. Now, if you are outside in the reserve, in the revenue lands, the Supreme Court also says that it is for the revenue to take a call, whatever they feel like doing it. That's a different aspect. But inside the reserve forest,
My lord, my respected friend has submitted, my lord, that there is no scope of de-reservation, my lord. But my lord, we have recently come to a record, my lord, a question has been put in the my lord, parliament, that how many hectares of land has been de-reserved in the state of Assam. My lord, it has several thousand hectares has already been de-reserved from the my lord, reserve forest areas also. My lord. So that is also not correct. But
that is
I'm
unlawful.
Mal.
That's unlawful.
Mal.
For that, I think it will be best for you to go before the division bench and tell it on the PIL that how it is being done.
For example, in respect of Amsang Wildlife Sanctuary, 7 hectare land has been de-reserved now, following the Conservation Act, 1980. Because the Gauhati Ring Road project is coming up.
it is challenging.
It is not challenge on their ground, it is challenge that can lesser trees be felled. That is the challenge. Challenge is not to the project. They say that has already been de-reserved. So there are projects of national importance, wherein
Yeah, that is, you see, de-reserve can happen. Under 22, they have
on
the power.
justifiable grounds.
But that is subject to the central government permit.
Exactly.
Now, if the central government permits, if the state wants to de-reserve and the central government permits, then there is no law which prohibits them unless it is being taken under 142 by the Supreme Court or an a PIL invoked or even by the division bench out here. That how do you do it? For me, sitting in the single bench, I can't look in.
My lord, that's why, my lord, the eviction should also not be selective also. Select to, my
That
lord,
is
get-
a question.
Mal.
Therefore, the question is,
Mal.
more pertinent thing is, with these 4 reserve forests, once it is being ascertained on the basis of these affidavit that
Mal.
these are the geographical coordinates,
will come
I
up.
think that if there is a selection being conducted, then it is another cause of action.
My lord, that is, I can understand, my lord, we are
On
accumulating.
that ground, the PIL was filed and was dismissed.
No.
My learned friend was appearing in that
See,
PIL.
Mr. Goswami, I also have understood there are some judgments of the Supreme Court wherein it says that the PIL being dismissed, that doesn't apply, res judicata does not apply. Mr. Bhuya knows what is to be done, but what do you have to say on 4?
Now, my lord, we are equipped with more records supplied by my learned friend, my lord, through these affidavits, my lord, it will help. My lord.
Now, anyway, what do you say
Mal.
about 4.3.1?
My lord, 4.3.2, that's.
Because
not-
you see,
not-
Mr. Bhuya, you have been saying that some people are there for 80 years.
Yes,
If you
yes.
are there for 80 years inside the reserve forest, you are entitled under the FRA Act. But at
No,
the time
75,
when the
yes, my lord,
matter
that-
was taken up by me
Mal.
initially, at the
Mal.
time when I issued the notice, it was categorically mentioned that you do not come within the ambit
No,
of.
my lord, I have
FRA.
categorically mentioned because, my lord, my mere submission before my lord, my lord, I have to submit fairly before my lord, my lord. Just submitting that we are residing there for last 8 years will not serve the cause, my lord.
You have
I
to
have-
show.
My lord,
So
I have-
therefore,
yes, yes, my lord. My lord.
once I pass a judgment, there will be a verification.
My lord.
Anybody having a claim.
Exactly, my lord.
No, nothing to do inside the reserve forest.
My lord.
Because that again to come with under the FRA Act,
My lord.
that has to be done through the Gaon Sabha.
That
That is another aspect which you need to have followed or not. Without, you see, there's a difference between a scheduled caste, scheduled tribe, and a forest dweller. Scheduled tribe, there is no period mentioned.
No, they have a right, my lord.
There is not even mentioned in a scheduled tribe will get it. But as regards, because one has to also understand that scheduled tribes are always attached to the forest. That is why they have been granted this status.
They are just like forest, my lord.
They are forest people,
My
so
lord.
they have been granted this status for that. And therefore, you have the constitution orders also wherein you don't have a scheduled tribe from Arunachal Pradesh. Some scheduled tribes from Arunachal is not recognized in Assam.
My lord. No.
The reason why it is not recognized because they don't hail from these forests.
From
They
there.
are there. So they'll get their protection there.
It is one kind of their birthright, my lord.
That's a
Remain there.
birthright.
My lord.
And in fact, if you see the evolution of the Forest Rights Act, it categorically mentions that all along there was a around 88 in the forest policy of 1988, more
Right.
particularly clause 5.3 or so. You see out there, they it categorically says that emphasis should be given as regards the scheduled tribe. This was the first time in 1988 this decision was taken that there some recognition were given to the forest, the scheduled tribes as well as the forest dwellers for the first time. Earlier there were so many agitations, nothing. It all happened on account of the things which were happening in Orissa and all. These people were there, so that was why it was. Anyways, that be
Under the land policy also, my lord, they can taken care of us also, my lord.
So therefore, as regards, you have a limited right for being looked into in terms of clause 4.3.1 of the forest policy for being placed in some other revenue place, like granting a settlement. Maybe you are holding such huge tracts of land, you may not. You may be granted some 5 acres or whatever, maybe if it's an agriculture.
So
These
those
are
for
things
town-
as per the Assam forest policy, land policy, it may go. Then it will come within the ambit of revenue. Therefore, I got hold of Mr. Arbor Pujari for revenue.
My lord, we have got some records and documents, my lord, of that Doyan and number, my lord, wherein some of the petitioners has some records to show, my lord, that their existence prior to 1980.
Yes, so that will be an inquiry being done.
Yes, yes, my
Prior
lord.
to,
If the
prior to
inquiry
any eviction, that inquiry will be done only for the purpose of maintaining
mal,
as to whether you will be entitled for settlement by the revenue.
mal.
That will be an inquiry to be done for which I have to issue a direction to the revenue
Lord,
to
I-
look into those for
Those
your
documents can
settlement,
be examined.
but
my lord.
nothing to constitute a right within the reserve forest.
No, no, my lord, no.
So by the time I deliver my judgment, I think you start packing.
My lord,
But
my lord, if the
I
judgment
make
is
it very
against us,
clear to you that
my lord, some time may be given, my lord, to us.
therefore the time is there. Time is given you. I've already been holding on to this matter for a long time. Other benches immediately
No, my lord,
dispose
from-
of the matters.
My lordship is gracious and kind enough, my lord. From the date of delivery, my lord, we need some time, my lord. If we need to vacate, my lord, obviously, we'll have to take, my lord, at least 15 days
Let
time.
me think into that aspect,
My lord,
what
my-
is to be done. But you see, this is how it is to be done. Anyway, Mr. Goswami, do you need to say? Let
Only
us
one thing,
hear
my lord,
Mr.
I prepared a list, my lord, of these coordinates,
Ah,
page
ah.
indicating coordinates.
All the four.
One thing I must admit, my lord, in respect of item number 7, that pertains to Borbani, my lord. 17, that list was not annexed with the A.
No, it's okay.
I have.
You have it.
Here, my lord, make keep it on record, my lord. And also giving a copy to my learned friend, my lord. এখানে coordinates to details may be on item 7.
I'll reserve it, giving you the liberty to file a short affidavit, one page
Yes,
affidavit,
ma'am.
just
I can
enclosing
file it by
that.
tomorrow.
Because it should be a part of the
My
records.
lord, I got it, ma'am. I got it. By tomorrow, my lord, I'll file tomorrow morning.
Yes, Mr. Borbidari, what do you have to say?
I'm sorry, my lord, during the course of the day, I write it down in my hand, my lord.
No, this is for Borbani.
This is for
No,
Borbani.
no,
This was not
What
annexed. in
about the others?
Others, my lord, already mentioned, my lord.
Oh, you have mentioned which page did you have
Coordinates
mentioned?
I have mentioned.
Okay. You just file one affidavit.
That Borbani thing, my lord, I'll file in an affidavit by tomorrow morning.
One page.
My lord.
Only that this is me. I give you the liberty while passing. the-
My lord.
Yes. Mr. Borbidari. Hey, yeah. It's only you are there. September, past. Yeah. Mr. Borbidari, what do you say?
Now, what has been challenged out here is twofold. Number one, my lord, the speaking order. In pursuance of the dictum pronounced by the apex court in Abdul Khaled, that you have to give them a right of hearing. Everything is done and the speaking orders are issued. The speaking orders are put to challenge, number one. Number two, my lord,
No, that fact remains, as regards the speaking order, they don't say much, but they say that they fall within the geographical codes.
therefore, since my lord, at the end of the day, it will be the revenue department who will take a call, my lord, if at all,
No, that is
Yes,
okay.
yes.
But the speaking order, passed by the forest department
Forest
or what, the
department.
committee which is there, but to the effect that they fall within the geographic coordinates of the reserve forest. So
Absolutely.
the limited scope of the sweeping order is as to whether they fall or not.
They follow law.
So therefore, the forest department has already filed affidavit proving this manner in which they have carried out all these things.
Yes.
And they say that these are what are the geographical coordinates of this reserve forest.
Absolutely.
And my opinion is that if anybody falls within these coordinates, then it will be falling within the ambit of the reserve forest. And accordingly, they have no right, having no
right
right being
whatsoever.
created on that.
Whatsoever.
So that is one aspect of regards the speaking orders. Speaking orders, if you go much in detail, it becomes a big problem, because you see, one also has to understand that these speaking orders are being passed by authorities who are not well addressed by law. So they may not have these speaking orders in a manner in which you or me or anybody would write the order to them.
Absolutely.
So we have to understand, therefore, the basic reason given in the speaking order is that they have said that they fall within the geographical codes.
So therefore, contrary has to be established by them. Since now the Department Forest has come up with all the detailed affidavits and everything. If a submission is forthcoming from their side, so it will have to have a overriding effect.
It could be just I call you for another purpose. Ask Vijay to know.
So
Geo coordinates to the answer. Yes.
So if we will come to 4.3.1 of the forest policy, my lord, 2004. Now 4.3.1.1, it says, my lord, government of Assam shall endeavor to identify pre-1980 encroachers who were allowed to enter the forest area by any competent authority with a view to finding a solution to their land-related problems. It does not, my lord, qualify as to what are the nature of encroachers. Now 4.3.12 says that encroachers who belong to ethnic communities of Assam and who have traditionally and characteristically dependent on the forest would be motivated to join the forest protection activities as economic stakeholders, providing sustainable livelihood support to the people who live in the fringe villages would be a major thrust activity of the forest department, so that fringe villagers would work as real protectors of forest. So a leeway has been given, my lord, to those encroachers, if at all, my lord, who come within the ambit of ethnic communities. Here is a
No,
case.
but there one has to say
Yes.
that portion of the forest policy,
Now-
thereby permitting anybody to enter,
Yes.
would be contrary again to the Assam, the section 2.
Yes. Now, if lordship sees thereafter, my lord, 4.3.1.3.
Let me find out the way.
But I'm going by
I
the,
gave it to these people with. some-
this is Assam Forest Policy 2004.
Cover this. Yes, got it.
Now, 4.3.1 begins with the broad category of my lord encroachment. Encroachment is one of the main causes of depletion of valuable forest in Assam. Then if we go further down, my lord, we find my lord 4.3.1.1. 4.3.1.1 I have just read, my lord. Then 4.3.1.2 my lord just read. Then
Now, 4.3.1.2
yes,
would come within the ambit of the FRA.
absolutely.
They are, although this is being mentioned as ethnic, you see what is being used. Ethnic communities of Assam who are traditionally and
Yes,
characteristically
characteristic.
dependent on the forest. Now, if you find the Indian Forest Policy of 1988, more particularly clause 5.3, you find out this is the expression which is being used out there. This appears from there.
Even my lord, that 2006 Act also speaks of a similar nature of my lord protection, giving a similar identification to those forest dwellers which have passage of my lord continuous occupation of 75 years. Now, if we see my lord 4.3.1.3, action plan would be formulated for demarcation and consolidation of reserve forest boundaries by permanent measures. Then my lord, next one, 4.3.1.4.
Now, this is what has been done here.
Yes. Then 4.3.1.4, these areas would be treated as People's Protected Area, PPA, inside forest, where the settlers create community assets of forest along with the services required for their livelihood. These PPA shall act as people's pool of asset for strengthening livelihood security of forest dwellers. Then 4.3.1.5, Government of Assam in Forest Department shall also take necessary steps to convert the forest villages to revenue villages as per the guidelines of Ministry of Environment and Forest, Government of India. Now, this has a linkage, my lord, with
This
section.
can be done.
This can be done because of my lord, clear mandate of section 2 of that 1980 Act.
Forest villages cannot be, because forest village, if you see chapter 3 of the 1891 Act, forest village has to be done in terms with chapter 2.
Yes,
Forest village, the settlement has to be done in terms with chapter 2. Thereby, only those persons
yes,
whose rights were created under sections or saved under 17, they will have a right. So they may constitute a pool. And on the basis of that pool, there might be a forest village.
yes,
Forest village, they might be a forest village, and thereupon it will then, but to make it a revenue village, yes, it can be done by the government, but it has to be done. The government can do it. Now, if we see the nature lovers
therefore,
case, the
yes,
government can do it, which was done by de-reserving it in consonance with the central government.
yes.
The government may very well do that.
So it's a two-tier mechanism.
Yeah, it's a two-tier.
It
So
is
this can
it's
be
a
done
two-tier
under
mechanism.
4.3.15. It can be.
Absolutely.
As you said in that earlier matter pertaining to, I remember that Imran Patta thing.
Yes.
It's a policy.
It's a policy.
It's a policy which needs to be either by way of an amendment to the act or doing something more which is required. So 4.3.1.5 can only be done by the state in consonance with the central government
Yes,
by taking a plea of de-reservation read with the permission sanction from the central government.
yes.
That can be done.
That can be.
But this court can't issue a writ for that. And so this is absolutely on the volition of the state.
Now, the emphasis here is, my lord, what is the basic characteristics of the petitioners out here? That they do not even fulfill the remote characteristics of being either a forest dweller or for that matter, by their avocations or occupation or their long
No,
continuous
if they are
occupation.
forest dwellers, then we would not have disturbed Mr. Rajiv Borpur.
No, but so-
I would have disturbed only Mr. Parangam
so,
Usman.
so therefore,
They
my
are not reserved for.
Absolutely.
forest
They are
dwellers, but
out
the
and out
fact
encroachment.
remains
Yes.
that if they were granted the permission by a competent authority of the forest park, then the state as a whole has to take care of that. Because what happens? Normally, there are many aspects. If you see how the reservation is being also made, the reservation is made in this manner. There are certain areas which are reserved, which are obviously because the land in Assam belongs to the government. So these areas are reserved, and okay, we are having this land. But somebody may be having rights. Then you have to acquire. Yes. You acquire those land and then you convert into a reserve forest. Yes. This is how you do it. Yes. So therefore, those persons get some benefits if they are within it or prior to the reservation. Now here is a case where certain rights were created prior to the 1980 Act to these persons to remain there. It may also include even the forest dwellers also. I'm asking, I may put a question to myself. It may also include the forest dwellers or even the scheduled tribes. Yes. But if you are going to evict them, yes, you are to give, the state has to provide them. Yes. Because some forest policy is not the policy of the forest department. It is the policy of the state. Absolutely. And as I always say, the state should speak in one voice. Yes. Now, therefore, my lord, this 4.3.1.2 gives some semblance of protection to the ethnic communities. Now, so far as these petitioners are concerned, in my respectful submission, they may at all, my lord, at the base, they may come within the ambit of 4.3.1.5. So whereby the government in Assam Forest shall also necessary steps to convert forest villages to revenue villages as per guidelines so and so. Now, or conversely, if we do not harp on this one, conversely, if we treated them as an encroacher simpliciter for a moment, encroacher simpliciter, then they will. I'm not on encroacher simpliciter. If there is an encroacher simpliciter, there is no problem. I'm on 4.3.1.1, where government of Assam shall endeavor to identify pre-1980 encroachers who were allowed to enter the forest area by any competent authority with a view to finding a solution to the land related
problem.
So therefore, these persons who have been allowed to reside, just for example, there are certain documents which Mr. Bhuya had shown that in 1974 there was this particular forest department or from the revenue authority or for forest department, there was a direction to the DC that kindly allowed these people to remain there. This is in 1974. And in pursuance to that, but there is nothing mentioned in those documents as to who are the people. Isn't it, Mr. Bhuya? That is a 1974 document which you have shown me.
My lord, those certificate issued to the Tongias, my lord.
And understood, but there is another letter written.
Yes, by
by
the
the deputy
department.
secretary to the forest department
My
to the
lord.
deputy commissioner that the government has asked them that these are landless people out there. They have
Oh, yeah.
some erosion effect. Kindly allow them to settle out there as a Tongia or something.
as a
to that
Tongia
effect.
scheme, my lord.
Now, therefore, these persons have been given on the basis of some competent authority. Now, we don't know. I don't know. Or either Mr. Bhuya may not also know, taking into account he may not have proper instruction as to whether these were the persons who are the petitioners were within the fold of this 1974 document.
Absolutely.
That is a question of verification
Pure
which
question
you
of
need to
fact.
do
Yes.
on the revenue side.
Yes.
So on the revenue side, as to whether these persons concerned were there in 1980, prior to 1980. So there will be either a voters list.
Yes.
Now it again strikes me back about the matter pertaining to Nagaland. Nagaland, what has happened in 1962, 1st of December 1962, Nagaland became a state. Now what happened at that point of time, in 1965, first the notification comes that look here, we are going to consider these persons as indigenous Naga inhabitants. First, if they had their names in the voters list prior to 1/12/1960.
Yes.
One. Secondly, if they had some patta prior to 1/12/1960. And thirdly, if they were paying house tax prior to 1/12/1960. But these would only apply in respect to those 11 Naga tribes, along with Karbi, Karbi, and the other one is, which one is there in Dimasa, and a few, 3-4. But in regards to Nepali people, they have another notification of 1939, wherein he says that these people have to be there prior to 1939. Then they are going to be given inhabited indigenous inhabitants. So this is the manner in which you may have to distinguish these people as to whether these people were there at that point of time, thereby getting any benefits at that point of time to the. So this is how you know it better.
Yes.
For consideration as to as regards that settlement in some area of the
Yes.
effect.
Yes.
This is how 4.3.1 because these are and this 1980 4.3.1.1. Now, if you just see I'll show you another thing. The Indian forest policy. You see, Indian forest policy 1988. And in 1989 or 90, the government of India issued various circulars, thereby trying to regularize those people who were residing prior to 1980. But it stopped in view of the Godavaran judgment, which happened in the year first order. Godavaran. Now, if you see it, as I was referring to, kindly see this. Amendment of state forest, country license. As I was saying, this is 4.6 is the tribal people and forest. Having regard to the symbolic relationship between tribal forest, people and forest, a primary task of all agencies responsible to forestry, including the Forest Development Corporation, should be to associate the tribal people closely into the protection, regeneration, and development of forests. Now, this is what you find in 4.3.
Yes.
You find that, no?
Yes.
Therefore, this is as well as to provide gainful employment to people living in and around the forest. So therefore, these purposes where it is being mentioned, the ethnic people, while safeguarding the customary rights and the interest of such a forestry program should pay attention to the following. One of the major causes for degradation of is illegal cutting, protection, regeneration, development, and soil. Shifting culture, damage to soil from encroachment. Now, so this is 4.6. For the first time, India recognized the rights of those people living in the forest. For the first time in 1988.
Because of their, my lord, social characteristics or whatever it is.
All along, they were never. Therefore, in 1990, you have those circulars issued.
Therefore, the idea appears to be a, my lord, inclusive, holistic approach
Yes.
to protect.
Huh? If you see my judgment in the Mizoram, I have dealt with this very aspect very categorically. Why? And why Mizoram scheduled tribes, they should be granted the benefit, taking into account 98% of Mizo are scheduled tribes. So in Mizoram are scheduled tribes. Now they are all and 80, I think they are the highest cover. 88.6% is the forest cover.
Yes.
Where will these people go then?
But there, my lord, the pattern is different, my lord. The social pattern is different, demographic pattern is different. Here we are dealing with a case, my lord, who this persons doesn't even, my lord, prima facie appears to be, my lord, connected with any forest activity for their livelihood, my lord, for that matter. So therefore, my lord, if we take 4.3.1.1, it the government of Assam shall endeavor, so if it is to be found out, my lord, whether these persons came into occupation of those reserved forests prior to 1980, then it will call for a fresh exercise.
That will be looked into by the revenue.
Yes.
So
Number,
therefore, my
number two.
directions will be to the revenue to look into that aspect. The persons who are claiming any right on the basis of being settlement, on the basis of being permitted by the competent authority, the revenue has to look into it. That is it.
With a
Because
view
it is
to,
not for this court also to direct the granting settlement, no.
because 4.3.1 doesn't speak of any solution. It says, my lord, the language is government of Assam shall endeavor to identify pre-1980 encroachers who were allowed to enter the forest area by any competent authority, comma, with a view to finding a solution to their land-related problem. So therefore,
Because the encroachers may also become ethnic people also.
ethnic people.
No, because you see the next 4.3.
Yes, so that protection is,
Encroacher who belong to ethnic community.
that is altogether minor defined clause. Therefore, that protection is given minor in 4.3.1.2. So admittedly and evidently, these petitioners do not come within the ambit of 4.3.1.2. This is my respectful submission. If at all, my lord, at all, they may come within the ambit of 4.3.1.1, provided that exercise is undertaken and it is found, my lord, that yes, they came into occupation prior to 1980.
Huh.
So that
No,
is
not
the
only
theory.
occupation with by allowed by competent authority.
Yes, occupation, yes, competent authority.
So then they will be given some settlement or some help by the state in the revenue.
The state, my lord, that rule 12 of the settlement rules. Pending settlement, you stay here.
What
For-
it may be,
for the
we may
time being, if we
consider, but
assume.
under no circumstances they can be in the forest.
Yes. So therefore, if it is found, my lord, that they do not come, they did not came into occupation prior to 1980, and that too without any support from any competent authority, then their status will be of, my lord, encroacher simplicity. This is my assessment. Then they
So,
will
Mr. Bhuya, did you vote at that point of time? You must have voted. You need two documents to satisfy them. One is the voters list, as I have indicated. The voters list, even the panchayat may not be there at that point of time, but the voters list was there. So voters list will be there, one. And then second is you have been authorized to remain on the basis of that. You show it to them, they will help you out.
Lord, my last, just summing up, my lord, a small 5 minutes, my lord. My lord, I have searched the various judgment of the Honorable Apex Court that whether there is any direction from the Honorable Supreme Court regarding the rehabilitation aspect of this type of encroachers. My lord, it is very difficult to find out, but in very few cases, my lord, the principle and the ratio of law, which has been, my lord, laid down, that the encroachers or the, my lord, illegal settlers or those persons, my lord, who are residing in various lands, not forest lands or other government land or the railway land. The Honorable Apex Court has taken care of, on humanitarian ground, has directed that before the eviction exercise is carried out, at least, some rehabilitation or at least being a human being, they should be given some shelter, And my lordship knows, that the in recent, that the eviction in Haldwani, Lord, in Uttarakhand, that railway cases, Supreme Court has categorically said, that you first show the rehabilitation or the resettlement scheme, then you should go for the eviction.
Mr. Bhuya, for railway land, I've seen many judgments of that.
There.
Railway land does not come within the ambit of Article 51A
No,
or Article 39.
No, not at all.
So therefore,
But
that benefit is not there.
But
But yes,
but-
if it was a case of a state wasteland, I would have definitely permitted that. But if it is a case of reserve forest, this
that is,
permitting you to remain in.
my I am
This
not,
court, after holding that you are an encroacher, you cannot remain in the reserve forest, thereby permitting you to stay for 1 day, would be transgression upon the powers conferred upon the central government under section 2.
that is correct.
You have to understand the
My-
predicament of this court also to that effect.
Lord, I will never
two-
submit. Lord.
Section 2
Fine.
permits only with the sanction of the central government.
Central government.
Now, today, if I do so, I would be holding means or keeping a blind eye to section 2 on the base. On the other hand, relying on section 2 for other matters.
No. That submission I will not make.
You see, the only
my
thing
lord-
that
my
is the problem which I see. Now, however, I think you see, therefore, I only found out 4.3.1.
Yes, my lord.
Nobody found
My
out.
lord.
It's not prayed for. I only found out 4.3.1. I only showed you what is can be done. Not the.
No,
But anyways,
proceedings are there, my lord, but the human rights or the value of being a human, my lord, the manner in which the welfare state is carrying out to a particular, my lord, section of citizens, my lord, is very heartening, my lord. That's the issue.
therefore, once we fix that four corners of these four reserve forests, thereafter, if there is an inequality to that effect, that is a difference to for the division bench to look into it. That they have singled out this ethnicity or this section of the people, but others have been not done. After being notified with these four boundaries out there on the basis of the geographical coordinates, you can very well take up an issue out there.
Yes.
Because earlier, when you were approaching before the division bench, you did not have those materials.
No.
Now you have these maps.
My lord, that PIL, my lord, that PIL.
I'm saying it. Now you have these maps. You will be conferred with the judgment of this court wherein on the basis of the affidavit I will be incorporating these four boundaries. After that, if there is somebody out there that they is singled out, then obviously you'll have a case. Is your look?
If you apply.
Mr. A.R. Bhuya, the learned senior counsel, assisted by Ms. S. Noskar, the learned counsel for the learned counsel, appearing on behalf of some of the petitioners, Ms. S.B. Chaudhary, the learned counsel, who appears on behalf of some of the petitioners, and so appears on behalf of. I've also heard Mr. P.N. Goswami, the learned additional advocate general, Assam, learned additional, assisted by Mr. I. Kolita, appearing on behalf of the state of Assam. In addition to that, I've also heard Mr. R. Pujari, the learned standing counsel of the Revenue and Disaster Management Department. First hearing is complete, judgment reserved. This court, however, finds it very particular. Hearing complete and judgment reserved. During the course of the hearing, Mr. P.N. Goswami, the learned senior counsel, learned additional advocate general, Assam, submitted, have placed before this court the geographical coordinates of Borapani Reserve Forest. Borapani Reserve Forest. It is the opinion of this court that the said geographical coordinates be placed by way of an affidavit, which Mr. P.N. Goswami, the learned additional advocate general, submits that the same would be done tomorrow. Taking into account that the learned counsels have been duly heard, this court reserves the instant batch of writ petitions for judgment. The interim orders passed earlier shall continue till the delivery of the judgments.
Lord, while the initial interim order was passed, Lord, the Doyang Reserve Forest was left out. Lord, may I pray that the Doyang word may be kindly be
Well, I have inserted.
Doyang.
I have passed those orders to the effect. I passed orders to the effect. They specifically. Initial interim order, no, thereafter.
Initial, when my lordship reserved the judgment on that day.
Lukmari, Nambor South, Borpani Reserve Forest, which are the subject reserve forests of the present petition. Yeah, interim orders passed earlier. As regards the Lutumari Reserve Forest. No, this court directs the respondent authorities to not to take any further steps for eviction in respect to Lutumai Reserve Forest, Nambol South Reserve Forest, Borpani Reserve Forest, as well as the Doyang Reserve Forest, which are the subject reserve forests in the present batch of writ petitions till the judgment is delivered.
Declare.
এই কাগজখন ইম্পৰ্টেণ্ট দেই বেছি লেখক কাগজ এখন দিছিল দিছো তাতে
My lord, the charge sheet is at page number 40. The lordship should kindly come to page 45. Sorry. Charges are at page 40. Unauthorized and prolonged absence from duty on medical ground, failure to appear before the medical board for medical examination to ascertain the nature of your illness and medical fitness as per the decision of the management committee. Then my lord, charge number 2 is at page 42. Leave applied and availed of by you on false and fictitious medical ground with an ulterior motive. Charge number 3, failure to furnish medical fitness certificate for illness reportedly suffered by you, contradicting statements made by you regarding the nature of your illness. In your prayer petition, give substantially the sanction of leave for your absent from period from the hospital. Then page 43, charge number 4, preemptive attempt to resume your normal hospital duties from 16/1/06 on the strength of a mere medical prescription, with your medical advice to avoid appearing before the appointed medical board for your medical examination on 18/1/06. Then disagreement and question of the management committee decision for constitution of a medical board to conduct medical test on you on account of your prolonged absence from duty on medical ground. Non-compliance with management's request for you to appear before the medical board on so and so. Then, my lord, at page 45, on top, 6, attempt to implicate the hospital management with all sorts of baseless, false and mischievous allegation by way of your letter communication sent to state government, central government authorities. Charge number 7, non-submission of proper account with supporting bills and vouchers for expenses incurred by you in respect of your total advance amount received by you for training program in pediatrics nursing undergone by you at Concord Nepal, Chennai. Submission of a telescopic bill of for a highly inflated and exorbitant amount as expenses incurred by you for training program with an ulterior motive to mislead and cheat the institution by misappropriating its fund for your personal gain. Misconduct by loss of tour expenses statement with supporting bills and vouchers of co-paramedical staff taken by you for preparation of your tour expense statement, resulting in a very embarrassing situation to her and eventually forcing her to submit her for the second time. Then below page 46, charge number 8, attempt to mislead the institution by submitting a fictitious tour expenses statement without any supporting bill and voucher for a very high amount of disproportionate one, etc. Then below page 47, charge number 9.
What about charge number 6, 7 and 8?
Yes,
There is okay. These are the charges. What does the labor code find?
yes.
As regards the others,
The findings are
penalty
there,
of-
my lord.
Here is that.
Inquiry report is at page 51.
Now, how does the labor code do it?
Yes. Now, page 63 onwards, sir.
I leave page 176.
176. Sir. That is the judgment. Now, I was trying to refer to the Millard inquiry report.
Inquiry report will look into it.
Yes.
Whether the question of inquiry report was gone into the fairness of the inquiry report
Yes.
and what does the court.
Now, Millard, if a lordship to kindly come to page 179. One second, sir. Please come to 174. Sir. Last para. More so when the charges were proved during domestic inquiry, which in turn were very fairly where the workman has given all sort of opportunities, including cross-examination of witnesses, scrutinizing the documents produced by the management, also adduce of defense evidence, learned counsel in support of his submission, referred to the decision of the Supreme Court rendered in the case of so-and-so versus so-and-so. Then, my lord, after referring to the Supreme Court judgment, on the other hand, as does learned counsel appearing for the workman, both in his written submission as well as oral submitted, that there is no iota of evidence accorded both in the domestic inquiry and before this court that she was involved with any untoward incident like theft, misappropriation, quarrel, or with other women, etc., which could have been termed as a measure of misconduct, warranting removal or dismissal. The learned counsel submitted that during the domestic inquiry, when the workman put question with the witness about the performance and behavior, they replied that her behavior was quite good and no any allegation against her raised during her service career. Mr. Bora, learned counsel further contended on the charge with the management side to project.
Can you come to page 179?
Yes, please.
First.
Now, first, in order to hold the
Submission
person,
of, submission of exorbitant bill
Yes.
during training by the workman.
per se cannot be held to be illegal and attempt to misappropriate. In order to hold the person guilty of misappropriation, he or she must be placed entrusted with the duty of financial transaction or property.
But whether bill was submitted,
Ah.
whether the money was taken,
Yes. Yes, yes,
money was taken.
yes. Money was given below there to reimburse, sorry, there to submit the bill.
Now, did you reimburse? If you have not reimbursed, there is no
Actually, I
misappropriation.
think if I have understood correct, subject to further clarification, Miller, I think when they go on tour, money is given, Miller,
No.
STA.
No. Let us see the charge.
Yes,
to that
yes.
effect. On misappropriation here.
Page 45. Advance
Yes.
deposit.
Charge 8. It has
Attempt
been
to
alleged
mislead
that
the
you have
institution
tried to
by
extract
submitting
money for the false
fictitious store exchange without any supporting bill and voucher for a very high amount disproportionate to the one estimated for your training program. That should have actually
So
been.
you have not made the payment. So where is the question of misappropriation? Misappropriation will happen when the money transfers.
If your lordship could kindly come to page 47, Miller.
That is what I am reading.
It has been alleged that you have tried to extract hospital money by submitting a false and inflated tour expense bill for an amount of rupees so and so, which is superficial figure projected by you, and this is proportionate to the actual expense incurred by you without any supporting voucher in respect of a trip to China for undergoing pediatric nursing training and so on. However, it is reported that your companion Gitanjali Devi has submitted a tour expense bill for only 15,000 for the purpose, which is such a lower amount than yours. This act of your product, it could have so happened, Milord, maybe some advance was taken.
No, then allegation has to be taken.
Right. Correct. Anyway, Milord, her action also cannot be. Now, the fact that, Milord, during the inquiry, charges were proved. Now, please come to 179, Milord. In order to hold a person guilty of misappropriation, he or she must be placed entrusted with the duty of financial transaction or property which he or she has used for benefit or diverted funds. So this may not be wrong. Management has absolutely laid no evidence to show an exorbitant bill paid by the concerned department of the management other funds. What crystallizes from the above discussion and observation is that even if during domestic inquiry the aforesaid charge were held to be proved, yet the charges are found to be of not so serious warranting highest punishment of removing the workman from service. Thus I hold that the punishment of removal of workman from service of management is indeed shockingly disproportionate to the charges. The aforesaid decision of the apex court referred to by the learned counsel for the management cannot be applied in the factual matrix of the case. In the ultimate analysis, it is held that the order of management removing workman is shockingly disproportionate and is thus liable to be set aside in court, which I accordingly do. WW1 in her evidence has specifically stated, since after removal her from service from management, she remains without any gainful employment. Therefore, considering all the above aspects in exercise of section 11A of the IDX is given the relief of reinstatement into service of the management in the same cadre with which she was holding before her removal, along with 60% back wages except the period of her absence. She is also entitled to litigation cost of ₹20,000. However, there will be stoppage of 3 increment, which is inflicted as punishment upon her. She send a copy on so and so so and so. Now, my lord, my only submission is, my lord, under section 11A of the ID Act, my lord, Labor Court has the power. Does not go to that extent. The question is, here is a case. She was already gainfully employed. That's why my lord, did all this mischief. Because in our affidavit,
And did you prove it before the learned trial court, before the labor?
that is the whole difficulty. That is the whole difficulty. Now, if your lordship should kindly come to page 225, we have filed an additional affidavit. In fact, my lord, she is working as a principal of a training nursing college.
From when?
I say that respondent number 2, Swapna Gogoi, is gainfully employed. I came to know from this source that respondent number 2 is currently gainfully employed as a principal in GNM Training School, Nalbari Maternity, situated in so and drawing a salary of approximately 1 lakh per month. Under the circumstances, respondent number 2 is not entitled to back wages as claimed and awarded at the labor court. It is like claim is so and so. And this is the booklet. I think the photograph is also there. Kindly see, my lord. So kindly see, my lord, she is working as a principal at page 4 of this booklet. Now, my only submission is
This is of which year? The document which you are placing, Mr. Chaudhary?
yes, sir. Thank you. Thank you. কেতিয়াবা কাম কৰি আছে উলিয়াব পাৰিবি। If your lordship say regarding entrustment, if your lordship should kindly come to page 45, charge number 7. Money was paid,
Where?
Yes, page 45. It is also reported that you were paid an amount of 5,000 on so-and-so and another sum of 41,000 on 10/3/25 for expenses to be incurred for your pediatric nursing training at the Netraloy, Chennai for a period of 3 months. But you were sent for training under SOS project as you were the senior most training staff. But till that you have not submitted your expense statement along with the relevant supporting vouchers and bills for the settlement of account. This is an intentional act committed by you with an ulterior motive to misappropriate the above advance given to you in spite of several repeated requests made to you. You have tried to evade the matter for long and eventually had submitted an unreasonable inflated false bill on the pretext or the other had made an attempt to mislead the hospital management or a ulterior motive and personal gain. You had told the hospital authority that all relevant bills and vouchers along with the tour expenses statement were lost. This is nothing but the sheer negligence of responsibility on your part, nature like you. So money was paid. And my lord,
That is the different money, Mr. That is a different amount. This is a different amount, that is a different.
only thing is, my lord,
This
in
is
the
a,
case,
this is
the charges were
another amount of this for 5,000 and another amount 41,000 on 10/5 for expenses to be incurred for your pediatric nursing training at Sankara.
My lord, overall, having regard to, my lord, kindly see, these are not, charges which can be said of a trivial nature. Some amount of responsibility is there, my lord. And she has also given up her claim for being sick. And the lordship has already recorded that in an earlier order. The question is back wages. And it's a case of unauthorized prolonged absence from duty on medical ground and failure to appear before the medical board.
Here your inquiry officer
Yes.
has put both charge 8 and 9, 7 and 9 together, 8 and 8 and 8 and 8 and
Basically, my lord,
8 and 7
charges
together.
are, my lord, basically she took leave. Then she didn't join for a fairly long period of time. Then when she said that I was on medical ground, I was on leave. Then she was asked to appear before the medical board. She never appeared.
But does it amount to such a misconduct that you are going to terminate? You may say that, okay, if you have not appeared before the medical board, then obviously there was also a leave being granted by the management for a month.
Some period. But only thing is, my lord, supposing a person takes a plea, end of the day, she is also in the medical service, my lord. End of the day, some amount of responsibility is there. I was only
Understood.
trying to understand this. Can it be said it is so disproportionate that it will shock the judicial conscience? On 11 a.m., I have no quarrel, my lord. Labor Code has the power to substitute, unless 226 code, 11 under 11 a Labor Code has power. I'm not on that. But question is, having regard to the nature of the charges, can it be said that it is so shockingly disproportionate? Kindly say, my lord, why you did not appear before the medical board? If you appear, then medical board will record a finding that she is not ill. That's the reason. So is she not trying to? Look, I think charge number 1 is pretty serious. Unauthorized and prolonged absence from duty on medical ground, failure to appear before the medical board for a medical to ascertain the nature of your illness and medical fitness as per the decision of the management. Some amount of a part of the period was adjusted against the leave due, but even thereafter there was a large gap.
But you have to also understand the leave during that period was subsequently given with retrospective effect by the management. So wouldn't that be condoning the action? I would have understood no leave was granted. Kindly come to page 63.
63 Miller. Observation.
The granting of
leave-
the leave
The
of the
granting of the leave of the charge sheeted employee from 17/8 so and so by later dated so and so was retrospective in nature and was given after more than 2 months from the time of receiving the leave application. Charge sheeted employee subsequently went to resume her duties on 16/1/26 and with the doctor's prescription dated 15/1, wherein doctor had indicated under advice that the patient can join her duty. Yet under the same advice, the patient has also been asked to report immediately in case of bleeding. But the advice puts a doubt in the mind as to actual health condition of the patient. The charge sheeted employee has submitted a prescription marked as Exhibit 6, which is dated 19/8/05, whereby she has been advised for complete bed rest. The same prescription contains advices dated 9/11/25, when she was advised complete bed rest too. A copy of this prescription was enclosed in the letter dated 10/11 of Mrs. Gogoi in reply to so-and-so's letter and is listed in serial number 9 of the list of documents relied upon by the man. It appears that charge sheeted employee is not in a condition to join her duty. Both the advice on both the dates of the prescription were for an unspecified period and therefore vague. Also, the copy of the prescription dated 13/12/2005 submitted by the charge sheeted employee and marked as Exhibit 5 does not speak of any rest. The advice in this prescription is for investigation as already advised, which indicates that advice of examination in the prescription dated 9/11/2005, which appears to be the last prescription before the prescription dated 13/12/06, were not carried out. This shows that the health of the charge sheeted employee was not of a serious nature and she had taken it very casually. It is seen from the copy of the prescription dated 13/1/2006 that it contains advice for the patient that the charge sheeted employee take 1 week's rest and check up after leave. But the charge sheeted employee had also submitted a copy of the fitness certificate dated 15/1/2006 and marked as Exhibit 3 just 2 days after the prescription, advising a week's rest is contradictory. The prescription advises rest for an unspecified period and a prescription advice slip declaring her just fit just 2 days after another such advice for a rest of 1 week cannot be considered as a statement of health of the charge sheeted employee. These prescriptions cannot be considered to arrive at the fact that as they contradict each other. As regards the second part of the charge regarding non-appearance of the charge sheeted employee before the Lord will kindly see she was also trying to cover up. She was trying to show that she was ill, well, she did not succeed. And disciplinary authority are the Millard judge of the facts. They have taken a view. Not the non-appearance before the medical board to satisfy the Millard.
Now, what happened after this first written statement was filed?
Yes. First written statement was filed on 21/2/2006. Then on 27/5/06, post the charge sheet, and inquiry report is 15/11/2006. Earlier also, my lord, this honorable court intervened and remanded the matter.
Oh, Where is the order of 18/12/2018? Asked in WBC number
Yes, my lord.
4776.
2011-18.
18/12/2018. Asked by this court.
Look, there's an order of 2011-18 at page 152 in WPC 4767 of 2010. 4776 at page 152.
2011.
Relevant page is 165.
My lord, page 164, para 26 onward. This court would accordingly require the learned labor court to assign proper reason for arriving at such conclusion that punishment of removal imposed upon respondent number 3 was shockingly disproportionate as reasons thereof are missing in the order. Accordingly, this court is of the opinion that the order passed by the labor court interfering with the punishment imposed by the management cannot be sustained in law. It is to be noted that power to vary punishment given by management lies exclusively within the statutory body, that is labor code, in the as the case may. Therefore, this code, instead of assuming the role of labor code and making an attempt to discover the reason for the conclusion arrived at by the labor code that the punishment is shockingly disproportionate, considers it appropriate that matter be remanded to the labor code to undertake the aforesaid exercise of spelling out reasons and recording the same in order to justify the conclusion arrived at by the labor code that the punishment of removal is shockingly disproportionate, which warrants its conversion to a lesser punishment as done in this case. Accordingly, for the reasons discussed above, present petition is allowed by setting aside the award passed by the labor code in reference case number so only with reference to interference with the quantum of punishment, so that London Labor Court can pass a fresh order justifying the reasons for interference with the award of punishment by the management and for imposing lesser punishment. It is made clear that since the award has not been challenged by the respondent, the finding arrived at by the labor court that the was
So therefore, the
has attained
scope-
finality.
only scope which was left, where?
Quantum of punishment.
Only on the quantum of punishment to be given, or why the reasons are to be assigned for interference.
Yes, yeah. Other issues are
So the reasons therefore are being given out here from page 176 onwards.
Yes,
Yes.
this much have to be examined.
And my lord, your lordships on a 1/11/25 had passed an order where lordship has said that lordship will only examine the aspect of
Back pages.
back 1/11/25.
We come to Annexure Exhibit 13. This is the very important letter. This is the letter dated 10th of March 2006.
Yes, my lord.
Whereas the charges amounting to gross misconduct and discipline against you have been leveled in accordance with service so and so as per the show cause notice dated so and so served on you. And you have refuted the charges which the management has not found it satisfactory. You are therefore placed under suspension pending inquiry of so and so. Your suspension has been considered necessary in order to maintain proper discipline in the establishment and to conduct proper inquiry against you. You will be entitled to receive a subsistence and suspension allowance of rupees 5326 per month during the period of suspension. The absence from duty before so and so will be treated as leave without pay. Then are you not sanctioning it? Then how do you take according to this and have it as a misconduct then? This was the document which was searching for. Because it is mentioned somewhere. This is the document. This document creates everything. This is for charge number one.
Means she has been condoned by.
You at the time of suspending her. Now the question is how much amount you will pay. One time settlement. I go as per this labor code disputes. Why should I write so much? With all this thing. It's to be settled. Sometime with a one-time figure
Let us have the instruction.
instruction, because this needs to be settled anyways. She's working now in a.
Another
good
gainfully
situation. It's okay, let her be there, but some compensation has to be paid.
Anyway, we'll take the instruction on
Yeah,
that.
she was the she has been appointed in the year 1994, 94, nah? I know better.
She is a cancer patient as well, breast cancer.
Therefore, prolonging this matter any further doesn't.
Let the matter come next thing. But I'll have the-
Have the instruction, go for a one-time settlement and finish it off.
Yes.
In fact, the 2010 judgment was more favorable to you. Was more favorable to you. You should have stuck with that. Now getting an order from here after 10 years and after 8 years and the matter then going back.
I think there's a lawsuit judgment also.
No.
Oh, no, some other, sorry. Next thing.
Get your instructions on this.
Next Thursday, Milord.
One-time settlement will finish it off. And this is, and she's a nurse, high standard nurse, so think about the compensation proper. It's not that I'm asking you to.
No,
go
no,
for
I followed.
that amount, but both sides should come up with a settlement. The amount can be not through mediation, through this court. What do you say, Mr. Dasgupta? This court will be better.
All right.
Because the matter at the end of the day, matter could be settled.
But that apart, no, she's a cancer patient, has an operation.
Understood. Whatever
Rest.
may be, but the one-time settlement would be
No, like,
better.
any amount. has-
Finishing it off unnecessarily.
Milord, first we'll figure out the entitlement, then we'll come out.
I'll
Or
figure out the entitlement, come up with a figure.
possible currently grant 10 days time.
Today is what, 13th,
Today
11th,
is
12th.
12, Milord.
Okay, let us have it on 19th. Can we do it?
Yes.
19th? The matter having been heard extensively. This court inquired with the learned counsel appearing on behalf of the parties as to whether an amicable settlement can be reached. More particularly taking into account the petitioner now is suffering on account of cancer. Mr. K. Chaudhary, the learned senior counsel appearing on behalf of the petitioner submits that he would obtain instructions in that regard. He would obtain necessary instructions from his assisting counsel in that regard. List this matter again on 19th of May 2026. Mr. Dasgupta, another matter, that matter pertaining to that one now, what you call Billworth. I think that the matter, there is some another petition filed that posted it on 12th of June. I have not issued notice to the effect. But there was a specific direction passed on the basis of a joint agreement that an amount of 64 lakhs or something would be
Yes,
paid
yes, yes, yes.
in 2 installments, and the payment has been made, something has happened, and there was a requirement for vacation of these premises by 31st of May. Look into that if it can be done properly, and because I have directed them to file affidavits of compliance for both the parties. Now they have come filed with a writ petition. I said that I'm not going to entertain this writ petition live. And accordingly, I posted it on 12/6. It's a different thing. But in the meantime, it can be sorted out. Just ask your client on that.
I don't have any contact.
That
Contact with that.
Billworth matter, remember?
Yes,
No, you were
Billward
assisted by somebody. Billward matter, where we
Yes.
fixed it out there. There was a question of lockout and issue.
Yes, yes, I remember this.
That we settled it out. I'd like to ask your assisting counsel to look into that aspect.
I don't have any contact. I will try to contact them.
Yes,
Sir, order of law, generally client does not keep the contact with the advocate. That is my hard.
but the thing is,
All that I shall,
I'm telling you because you appeared out there, because you are a senior counsel on this aspect, so you'll be better
No, I
known
will-
how
I'll-
to tackle out these disputes better than me.
well,
Yes, Mr. Das, in your matter.
But we received the opposition which were on sixth only, actually, we were supposed to receive it by 27th. So my reply is not yet ready, madam. So we need some time to.
Filed a petition on 4/11/2025. What is
No,
that?
no, my lord, they filed they were granted an opportunity. They filed some wrong affidavit, my lord, opposition. There was some mistake in their opposition.
Ah,
So they filed a fresh, my lord, affidavit in opposition in 6660, my lord. And we are supposed to respond to that by 7th, actually, but we received it on 6th itself. We are not yet ready with the affidavit, my lord.
It has been submitted that the affidavit on behalf of the state of Sam has been filed only on 6/5/2026.
Correct.
And the petitioner would like to file a reply there again in the petition number 660/2023. Accordingly, list this matter when?
My lord, on 11th or my lord, 16th of June or 18th.
11th, Mr.
Correct.
Gogoi?
Well,
On 11th of June 2026. In the meantime, the reply be filed on or before 8th of June 2026.
Correct.
11th of June, 2 p.m.
Don't, my lord, kindly don't fix the time because I come from outside. So if I get the opportunity to do in the first step, so I'd like to have the, because it will take some time also to argue. That is why I'm requesting. It takes, because two matters are there, my lord, and I need some time to argue. So 2 p.m.
Want
I
to know what is the matter about? I heard you on that matter.
Lord,
That day
briefly,
only one-
briefly, your lordship heard, but I had not yet, my lord, made
If you
my.
fix it at 2, then you have a chance of the matter being taken up. If I have it at, you don't fix the time, then you don't have a matter of taking. You have the option now.
No, better not to fix the time because, my lord, I come from Calcutta, and if I get, my lord, I will take my chance, my lord. If it comes in the first step, so I get more time.
That's it. 2 p.m. to decide.
Great.
Mr. D. Sahu, what is this? Harding part. That matter, huh?
Yes, thank you.
What is that matter pertaining to within?
Meanwhile, I could trace out some other Supreme Court decision.
In that
In
thing?
2001, ARSC, three judges bench on interpreting the provisions of the representative consent.
This is pertaining to that matter pertaining to that talak or something to the Muslim one.
This is another. So here also the same, they have interpreted section 9 of the.
Representation. Why you are giving two copies to me?
No,
Then what are you
it's
going
like
to
legal
read?
department. Two
Or
copies.
you want this to be passed to me?
No, sir,
Huh?
by mistake.
Then why are you giving it to me? It's okay, but what about We are concerned with within. Why you are referring to
Within 1 year from the date of commencement of commercial production.
So how will this judgment be applicable?
This says within 45 days from the date of the election.
Where? Period of limitation for filing an election is 45 days from the date of election of the return candidate. Here the word is from.
Oh, yes. In this case also the from.
No,
Within 1 year from the date of commencement of commercial production.
okay, from.
Within 1 year from the date of commercial production.
So you therefore say the first day has to be extended. And
Initial date
other
will be-
judgments which you have referred to,
Yes, other.
the other Supreme Court judgment,
Yes,
that gives a insight on what is within.
yes.
In this way was within 1 calendar month after the cause of such complaints in the held. So on the principle that the day on which the cause for complaint arose has to be excluded by computing the period of limitation. Oh, the date of commercial production has to be excluded. And what was the date of commercial production?
29 March 2017.
29 March 2017. Okay. And you submitted on 29 March 2018. Okay. So if that is so, from 2030, it should be recorded.
So
And therefore, it is within 365 days. It can be 365. Because if you have 365, then you have a problem because you
Actually-
here.
Rotation is 1 year. There's no, he says that will someday, something.
I did say,
Different.
Mr.
Something will be different.
R.K. Dev Chaudhary. Mr. D. Sahu is armed with so many ammunitions. He was not satisfied with the judgment of Alok Gupta, which were 2 judges. He got another judgment which was 3 judges. Now, these 3 judges have been followed by another judgment in 2014, 11/6/76 That is one. Then you have another judgment in 99/3 SEC page 1. Isn't it? That is Saket India Limited. These are all on the section 148 of the negotiable. That's where you have to give within 1 month. Huh? They all says the same. Mr. So has left nothing unturned. Huh? But I'm not opening up the 1 day more. I'm saying I'm only interpreting that this word has to be taken by applying as there is no definition as to what is the 1 day would be. So we have to import the judgments wherein, and more particularly the judgment in the case of Haru Gupta. Haru Gupta is a judgment wherein the law which was lying was a order pertaining to detention. And there they relied on the very common law principle out there. However, volume of authority in England showing that a certain thing has to be done within a specified period, the day on which the cause of action arose is to be excluded for the computation, and the day on which such action is taken is to be included. So therefore, they have to include the action which is to be taken. Means the last day has to be included. That is, means the last day has to be included. In some cases, the last day is accepted, but when it is the word within is being mentioned, then you have to exclude the first day, but include the last. And here specifically, as alleged act has been committed on May 30th, was within, you see the held that a complaint under Prevention of Cruelty Act filed on June 30th in respect of an alleged act alleged to have been committed on May 30th was within 1 calendar month. Calendar month, because May, June. After the cause of such complaint shall arise. He held so on the principle that the day on which the cause for the complaint arose, that is the day on which the offense occurred, had to be excluded while computing the period within which under the act the complainant had to file. In William versus the statute, this directed warrant of attorney to be filed within 21 days after their execution. And it was held that the warrant executed on the 9th day of the month would be regarded as having been filed in the proper time if filed on the 30th, the day of execution being one which have been excluded. On the other hand, in a case where the settler by the settlement of the conveyed the real estate up to the use of the trustee, upon the trust thereafter declared, it was held. It was thereby held that there should stand possessed of the said premises during the term of 21 years from the year so and so. And the said term of years sell the said premises so and so. His decision showed that the court has drawn a distinction between a term created within which an act may be done and a time limited for doing of an act. The rule is well established that when a particular thing is given from a certain date, within which an act is to be done, the day on that date is to be excluded. The rule was followed in Cartwright where the expression 15 days from the date of commencement of the policy in cover note covered by an insurance company was construed as excluding the first day and the cover note to commence at midnight of that day, and also in marriage and assurance. Here, in computing the period of 3 months from the date of detention, which was so and so before the expiration of which the order of decision for confirming the detention and confirmation thereunder had to be made, the date of commencement of the detention had to be excluded. So that the order of confirmation was made before the expiration of the date of 3 months from the date of detention. It's a very beautiful judgment. Short, very precise. So we refer only one and say that this point has been followed in other judgments. Not like to make it very long. Heard Mr. D. Sahu, the learned counsel, appearing on behalf of the petitioner. Mr. R.K. Dev Chaudhary, the learned senior counsel, as well as the DYSGI, appears on behalf of the respondent number 1. Mr. M. Setia, you have the power to appear for industries. Yes, madam. Yes, madam. You can appear. Okay. Because you are the main problem. You have caused the problem now. Mr. M. Setia appears on behalf of the respondent number 2 to 6. The present writ petition has been filed challenging the action on the part of the respondents in rejecting the claim of Central Capital Investment Subsidy Scheme, which the petitioner claims to be entitled to. The brief facts which led to the filing of the instant writ petition are that the Ministry of Commerce, that the Union of India had announced the Northeast Industrial and Investment Promotional Policy 2007, dated 1/4/2007. In pursuance to the state declaration of the industrial policy, the Ministry of Commerce and Industry, Government of India, Department of Industrial Policy and Promotion, issued a scheme for granting incentives towards the capital investment, and the said scheme was known as the Central Capital Investment Subsidy Scheme 2007, dated 27/7/2007. The said scheme was given effect from 1/4/2007. The petitioner being interested and the petitioner being encouraged by the Northeast, by the industrial policy notification of by the industrial policy incentives declared by the office memorandum dated 1/4/2007 changed his position to set up a new industrial unit. It is the case of the petitioner herein that to avail the benefits under the Central Capital Investment Subsidy Scheme 2007, for short, the scheme, various eligibility conditions were set out. Where? Which clause? Where did it say that you have to file? Within 1 year?
Within one, page 39, clause 7. Operation guideline.
Various in addition to that, for giving proper benefit and for operationalizing the scheme, and operational guidelines were issued on 7th of May 2013. The said operational guidelines stipulated the conditions as well as the manner in which the benefits under the scheme were required to be applied. Clause? Wait.
Clause 7.
Clause?
7. Page 39.
Which clause?
Clause 7. Roman 7.
For the purpose of the instant dispute, clause Roman 7 of the operational guidelines are relevant, and the same is reproduced herein under page 39. From a perusal of the above quoted clause, it would be seen, it would be apparent that the claim for subsidy under the scheme to naam to koi dibo CCIS scheme. Under the CCIS scheme have to be submitted to the concerned BIC in the prescribed application form within 1 year from the date of commencement of the commercial production. Within to bold. The petitioner admittedly went into commercial production on 29/3/2017. And this aspect is apparent from, where is that document?
Page number 62 or 67. Page number 67.
Apparent from? Immediately went into commercial production on, what is your name?
Serial number 2, page number 67, that mentioned the commercial one.
Bill number 2.
In 58 state level commission.
What is the name of the commission?
State level
PP plus
67.
6. Where PP plus 1? We are associates. Page 62. Huh?
End, page number 67 at the end,
Page
67,
67.
serial number 2 at the bottom.
It is an admitted fact that the petitioner went into commercial production on 29/3/2017. However, the petitioner filed the application seeking benefits under the CCIS scheme on 29/3/2018. Concerned respondent authorities in the minutes of the meetings held on four nine six four 2019, 10/10 2019, and 17/8 2022 rejected the claim of the petitioner for the central capital for the CCIS subsidy on the ground that the petitioner had filed the application beyond the period of 1 year. It is under such circumstances the petitioner, being aggrieved, has approached this court by filing the petition. The record reveals that this court, by an order dated 19/9/2022, issued notice the record reveals that the respondents number 3 and 4 have filed an affidavit in opposition. Wherein the stand taken at paragraph number 4 and paragraph number 7 here it says date of commercial production on 26/3, page 129. Then let's see the minutes. Ah, Though as per the inquiry report, date of receipt of the shown demand, the application was submitted. But on so and so the application is completed type and not approved. However, originator acknowledgement is not submitted. It's submitted on one day after the completion of 1 year and date before the for its admissibility and resolution. Show me the other one, the next one. PP plastics. Eight. PP plastic. Na? Very, it is stated that as the petitioner did not submit the application within 1 year from the date of the commercial production on its expanded unit. It is an expansion unit. Said, why you were saying when I said new industry, you said yes. Yes, 9 but not in there. From this only I come to know. Finally see page 86.
Thereafter, that expanded.
Then when I asked you whether it's a new, you said new. Mr. In this is new.
As per the industrial policy, they knew thereafter is expanded.
Being encouraged, took steps for expansion of its industrial unit. And in respect to and went into commercial production of the expanded unit on 29/3/2017. Full stop. Full stop. এই বস্তু আগত ভৰাব লাগে। It was also mentioned at paragraph number 13 of the said affidavit that the petitioner submitted the claim application belatedly, that is, on the 366th day from the date of commencement of commercial production on the expanded unit. The question which arises in the instant proceedings as to whether the filing of the application by the petitioner seeking seeking benefits under the CCIS scheme was delayed by 1 day. inasmuch as it is an admitted fact that on 29/3/2017, the petitioner went into commercial production of its expended unit, and the petitioner had filed the application on 29/3/2018. For the purpose of this court have duly heard the learned counsels appearing on behalf of the parties and have given an anxious considerations to the materials on record. First, the question as to whether the petitioner had submitted the application belatedly has to be ascertained on the basis of the operational guidelines, more particularly clause 7, Roman 7, which have been already quoted here in above. From a perusal of the said, from the above quoted provision, from the above quoted, from a perusal of clause Roman 7, it is seen that the prescribed application was required to be filed inverted comma within 1 year from the date of commencement of commercial production inverted comma close. Within and from with the whole going. The question therefore arises as to what meaning can be given to the terms within, to the term meaning, as to what would the above quoted phrase connote. This court finds it very pertinent to take note of the judgment of the Supreme Court in the case of Haru Das Gupta versus State of West Bengal, reported in 1972, 1 SCC 639, wherein the Supreme Court was dealing with the question as to whether the order of detention was passed within the period of 3 months from the date of detention. The Supreme Court explained as to what the term within connotes. At paragraph number 4 and 5 of the said judgment, the said paragraphs being relevant for the purpose of the instant proceedings are reproduced hereunder. From the above, the above principle of law as laid down by the Supreme Court clearly shows that when a particular time is given from a certain date within which an act is to be done, the day on that date is to be excluded. The said expression of law, the said law, the said principles laid down by the Supreme Court In the case of Haru Dasgupta, Haru Das Gupta, Supra, have been followed by the Supreme Court in the subsequent judgments in the case of Sanket India Limited versus India Securities Limited, reported in 1999 3SCC 1, as well as in Econ Entry Limited, ECON Limited versus Rom Industries Limited, reported in 2014 11 SCC 769. This court also finds it relevant to take note of the judgment of the Supreme Court in the case of Torun Prasad Chatterjee versus Dinanath Sharma, reported in 2008 SCC 649, wherein the Supreme Court was dealing with the limitation for filing an election petition in terms with section 81, bracket 1 of the Representation of People's Act 1951. The Supreme Court, while dealing with the said provision, draw reference to section 9 of the General Clauses Act 1897. And observe that applying, observe that when a period is delimited by a statute or a rule which has both a beginning and an end, and the word from, inverted from, is used indicating the beginning, the opening word is to be excluded. And if the last day is to be excluded, the word to is to be used. It was also very categorically observed that in order to exclude the first day of the period, the crucial thing to be noted is whether the period of limitation is delimited by a series of days or by any fixed period. This is intended to obviate the difficulties or inconvenience that may cause to some parties. Paragraph number 12 and 14 of the said judgment being relevant is reproduced here in under. Taking into account the above principles, it is therefore the opinion of this court that reading the expression, the phrase within 1 year from the date of commencement of commercial production, inverted comma close. The opinion of this court that the freeze, so and so. The opinion of this court, that in terms with clause Roman 7, as quoted here in the above of the operational guidelines, the application form has to be filed inverted comma, within 1 year from the date of commencement of commercial production, inverted comma, close. Which would mean that the date on which the commercial production, the date of commercial production has to be excluded. And the last date for filing has to be included. Accordingly, in the instant case, as the date of commercial production is on 29/3/2017, the period of 1 year shall commence from 30/3/2017. And the application which was filed by the petitioner being filed, which was filed by the petitioner, and the petitioner having filed the application on 29/3/2018, it is the opinion of this court that the said application was filed within the period of 1 year from the date of commencement of commercial production in the expended unit of the petitioner. Accordingly, the petition stands disposed of with the following observations and directions. The application filed, number one, filed by the petitioner on 29/3/2018 was well within the period prescribed in Roman 7 of the general operational guidelines for registration of industrial units and procedure for handling subsidy claims under the Central Capital Investment Subsidy CCIS scheme of NEIIPP 2007. Number two, the impugned minutes of the meetings dated so and so, so and so, and so and so, insofar as the same relates to the petitioner, is interfered with. First, number three, the respondent authorities, more particularly the state level, what is that? More particularly, the Principal Secretary, Industries and Commerce Department, Government of Assam. Is it the Principal Secretary or Additional Chief Secretary now? As well as the respondent number 6 are directed to, again, consider the application filed by the petitioner on 29/3/2019, 7/18, claiming benefits under the CCIS scheme. First, Number 4. This court have not decided as to whether the petitioner is entitled to the parameters, is entitled to the benefits of the said scheme. It would depend upon necessary verifications being carried out by the concerned respondent authorities. However, for the sake of clarity, it's observed and directed that the respondent authority shall it's observed that the application so filed by the petitioner is well within the period of limitation provided in paragraph clause Roman 8(7) of the general guidelines. The said exercise be complete. Number 2, the exercise is directed to be conducted by the respondent authorities be completed preferably within a period of 6 months from the date a certified copy is served upon the respondent. Number 3. 3 or 2? 2. 2. Just find out whether it is additional chief secretary or chief secretary or commissioner and secretary. Mr. Sahu is otherwise a great tax lawyer and a very all these revenue matters, but he is a bit problem with these persons to be made public. Isn't it, Mr. Sahu?
No,
Yes. What? No cost. Anything more you want? Enough.
This solves the problem. This solves the problem.
Serves the purpose. Fantastic. In fact, today I was thinking, what has happened to this matter? And otherwise, this matter is taken with me. Because most of the judges, they don't take up this matter. Now, the last time I was taking up a decision that they are saying that they are doing some map or something, I've asked them to find.
Madam, one affidavit was directed to be filed, whether this camp is lying within the.
To account the above, this court directs the principal to bring on record by filing an affidavit as to whether the eco camp in respect to which there are was a memorandum of agreement with their life within the whole area or not area. Have you filed the affidavit?
Madam, we have received the instructions.
No instruction. Affidavit.
We will file it.
What is this?
One more.
No, why are you delaying it? Does it take 5 months, 2 months?
One,
Or has he contested the election, this fellow? Then
one affidavit we file, but.
Next
we
week.
file this
next week.
Next week.
Otherwise, we are going to, because I want it on record. You see what has happened. They have a strong allegation against you that you are throwing him out so that you want to give it to somebody else. They have a case that clause 9 is not met. I tell you, they have a case that I also am the view that clause 9 is not met for them to terminate the contract. Be that as it may, you have taken a defense. Then look here, whatever it may be. This is in the core area. So therefore, the petitioner cannot be allowed to do anything. Don't it your stand. So therefore, if that be so, their allegation which is there, that look here, they want to throw us out so that they want to give it to somebody. If it is an core area, you cannot give it to anybody. Therefore, put it on affidavit.
I'll put it down.
Or is it that you are shying away to give it to somebody?
No, my lord, we are.
It appears to so. It does it take for 2 months for you to file this affidavit?
We just received the instructions. We
No,
will have filed.
the person doesn't understand the English language where I put it. Taking into account the status, policy. On the other hand, Mr. D. Gugoi, the learned standing counsel, Forest Department, referring to the appendix A and B of the Wildlife Protection Act, so and so submits that the eco camp is situated within the core area and the area has to be treated as a sanctuary in terms with section 33 of the Act of Iman Miradi. Taking into account the said aspect, This court directs the principal chief conservator of forest to bring on record by filing an affidavit as to whether the eco camp in respect of which there was a memorandum of agreement with the petitioner lies within the core area or the buffer area of the Namari National Park and so and so. File it.
Yes, we have got the answer. We will file.
We don't require these answers because tomorrow that answer you will see that that person has retired. We don't go under.
We'll bring it on.
If this is the same matter, they also cannot claim it. Yes. But it cannot be a your instance to give it to somebody else. Understood? Yes. No, don't play any more tricks with the court. Mr. Ibo Thakur, the learned counsel appearing, standing counsel appearing on behalf of the forest department submits that he has already received the instructions and the affidavit has also been prepared and the same would be filed within a week's time. List this matter again on 19th of May 2026 at 2 p.m. for final disposal. The affidavit be filed without fail on or before. Today is what? 12, no? 12. No, not 19. We'll have it on 21st.
20.
To file on or before 19th of May 2026. Not hearing. Who wants to do hearing?
Public.
Okay.
Fix any lots in a fix any day.
Okay, if you want to take dates, take dates. What is that? Oil India?
Yes, no. Dismissal from service.
Huh?
Pursuant to the departmental proceeding, dismissal from service. Thereafter, they went to the work court lordship.
Oil India?
No, lordship. McLeod Russell. McLeod Russell.
Network?
McLeod Russell lordship.
McLeod Russell. McLeod Russell. So this is a complete stake.
Yes, this.
And the other hearing? What is the other hearing for? Fishery?
Yes,
What happened? Have you got an interim order?
yes, Lordship, we are in an interim order.
You're enjoying an interim order. Then enjoy. Why the matter is fixed for hearing?
But its pleadings are completed.
Fishery?
Officially.
How many years are you enjoying? Or
No,
nobody is
basic-
enjoying?
Basically, the issue is, well, what they claim is that we claim that this is a public pond used by the village miller, and the fishery department has issued a NIT which we put to challenge.
Oh, that one where Mr. Kane Chobi is appearing.
No,
This is another one. Okay, there's also another tea garden land where there is a fishery. They have, without acquiring the land, they have converted into a fishery in another road. Are there two matters? No,
No.
those are different.
perhaps the issue would be somewhat like that only, because we have also said they claim that it is a fishery department spot. We said that there was never a notification under the land review regulation declaring this, because this fishery has a history. It's from Ahom Kingdom, and it is used by the villagers as a public pond.
Then
And they claim that, and the name is also changed. In the revenue record, it is said Aurora Rajoha Borpukul. They claim it is a Aurora Fish Seed Farm, which was run by Fish Farmers Development Agency since 1990. In fact, there was a specific query from this court as to since when this was classified as Aurora Fish Seed Farm, but in none of the affidavit they have disclosed that. And the land revenue records also.
But what do you say about the notification which was issued by the governor on 7/4/2021, if I'm not wrong? Whereby many of the forest, because they have taken away the powers from everybody and has given it to the fishery department. And more particularly, the regulation 8, where the deputy commissioner has been empowered,
Regulation 16, I guess.
16 or
16.
16. Then
But that is the specific question which we have raised in this repetition. There has never been a notification declaring it to be a fishery under the fishery department. And there was a categorical
So there is
instruction.
a notification required.
Yes.
And there is also to be recorded as per the fishery rules. With the
Yes.
fishery, it has to be recorded.
Recorded.
As
Yes.
per rule 2 or something.
Yes. Yes.
64 rules.
64. And that perhaps would be the pertinent question, Malor, which the
So
government.
who is running it?
Malor, fishery, the local villagers.
Is the public
It's a
interest?
no.
Then nobody here, I don't know. The single bench can't take up. Take up. How many persons are there? Petitioner?
2%.
How?
Plus there was
When they are not
That is
registered,
done through representative capacity. That concept is not there in the
it's not a public interest litigation.
Anyway, why should I dismiss one? Okay, well, when do you want it? You have no urgency.
No, we have urgency, but next week.
And he also has the urgency. Mr. Das, you have urgency. You are getting your last day, last round wages.
Dismissed from service. He was already dismissed from. 2010 Labor Code Award was passed.
Oh, then why you are not in urgency?
Okay, 2010 Labor Code Award was passed. He approached this code 2018. After 8 years.
Yeah.
8 years.
And the court had issued notice
He,
and have admitted it. Then then what is there? Back wages? Where is the question of back wages? How can I grant you back wages? You filed a section 2A. 2 capital A application or was it a reference?
no reference. Reference.
Okay. Okay, when do you want? Take your deeds, sir, both of you. Interim order is there, we have to continue or is it?
interim order. Interim order.
If we do one thing, we take it up for disposal on any other date. Can we have it on the 11th of June? We fix it at 2 p.m. Final disposal. 11th of June. 11th of June.
Our matter may be fixed. The first week of June. Also.
Okay. Anyway, your matter, I fix it. I'm anyways not there in the first week, so let it fix it on 4th of June. 4th of June, and matter to 11. In order to continue till the next date. Grateful.